Ladies and gentlemen, could you take a seat, please, and join me in singing happy birthday to our chairman. Happy birthday to you. Happy birthday to you. Happy birthday, dear Mr. Chairman. Happy birthday to you. Now, I realize that I don't sound like either Marilyn Monroe or Lady Gaga.
Do you want to vote on that? Thank you very much, Mike. And I guess good morning. This meeting will now come to order, if that was any order. And I guess happy birthday to my twin brother, Rob, as well. Thank you. This is a meeting of the Commodity Futures Trading Commission to consider rules under Dodd-Frank. And I'd like to welcome members of the public, market participants, and members of the media, as well as those listening on our webcast and on the phone. I'd like to thank Commissioner Dunn for that kind rendition of happy birthday, but also thank him, along with Commissioners Summers, Chilton, and O'Malley, for all of their significant contributions to the rule writing process, and thank the hardworking staff that have been working day and night and weekends to complete these rules as we go along. During today's meeting, first we will consider staff recommendations providing further exemptive relief consistent with what the CFTC had done this past July in an exemptive order for certain provisions of Dodd-Frank's Title VII that would have gone effective that point in time in July. And as I think I said at that public meeting, I think as we all deliberated, that as we got later into the year, we'd look at where we are and consider further exemptive relief to give us time and the market time as we are in this significant effort of completing rules. Next, we will consider a final rule relating to core principles for derivative clearing organizations. And lastly today, we will consider a final rule that relates to position limits. Position limit regime in the commodity futures and swaps markets has been a critical component of comprehensive regulatory reform on the derivatives marketplace. Today is our 20th meeting to implement Dodd-Frank rules, and as we continue our work to complete the rule writing, I think it's critical to remember why we were here in the first place. And though it's been 3 years since the financial crisis, we cannot forget the weaknesses that it exposed in both our financial system and in our regulatory system. I think we cannot forget the millions of Americans who really had no connections to the derivatives marketplace or any other exotic financial contracts, but still lost their jobs due to a poorly regulated industry, or more accurately, maybe just parts of an industry that were not regulated at all. And that's a criticism of the regulatory environment that failed for sure. We cannot forget the millions who lost their homes, or homes are worth less than their mortgages. Somewhere in the vicinity of 20 to 22% of homes today are actually worth less than their mortgages if you look at the whole mortgages outstanding in America. And though there are many causes to this crisis, swaps certainly played a role, the unregulated swaps market. So the package of reforms in Dodd-Frank will help address some of the contributing factors to the 2008 crisis. They are real concrete measures that will bring transparency, openness, and competitiveness to the swaps market while lowering the risk they pose to the American public. Now, there are some that would like to roll back the reforms of Dodd-Frank, put us back in the regulatory environment that preceded the crisis 3 years ago, but that regulatory system failed to protect the American public. And I think that what we must not forget is the people that have lost their jobs, or that the nation went through some very critical times, and we're still bearing the cost of that today. Some have also raised significant questions about costs in our rulemaking, and I will say that we have greatly benefited from those comments on costs. They've been very helpful, and as we go through provision by provision to consider how we finalize these rules. but it's also important that we consider the cost of an unregulated market and what that left us in 2008. So I will say things about each of these rules when we get to each of them, but before the staff presents here today, I'll recognize the commissioners for their opening statements. Commissioner Dunn.
Thank you, Mr. Chairman. And thank all of you for joining us today for another meeting to consider the final rules promulgated pursuant to Dodd-Frank. Today we consider rules in two areas, position limits and derivative clearing organizations, and we also can consider a proposed amendment for the effective date for regulations, swaps regulations. When the Dodd-Frank Act was originally conceived and then became the law, the fiscal crisis of 2008 was fresh in everyone's mind. It wasn't necessary to explain why Congress and the President chose to overhaul the country's financial regulatory system. Put simply, parts of it were broken. Parts of our financial regulatory structure did not work, and because they did not work, the people in this country suffered greatly. Today, years after the crisis ended, I think people have forgotten how it all started. For these people, I'd like to remind them of why Dodd-Frank is important by examining some facts about what went on in 2008. And this amplifies a bit, Mr. Chairman, on what you had started saying. Number one, the financial crisis cost the U.S. an estimated $648 billion due to slower economic growth, as measured by the difference between the Congressional Budget Office economic forecast made in September 2008 and the actual performance of the economy from September 2008 through the end of 2009. That equates to an average of approximately $5,800 in lost income for each U.S. household. The U.S. lost $3.4 trillion in real estate wealth from July 2008 to March of 2009, according to the Federal Reserve. This is roughly $30,300 per U.S. household, and further, 500,000 additional foreclosures began during the acute phase of the financial crisis than were expected based upon the September 2008 CBO forecast. Number three, the U.S. lost $7.4 trillion in stock wealth from July 2008 to March of 2009, according to the Federal Reserve. This is roughly $66,200 on average per U.S. household. Number four, 5.5 million more American jobs were lost due to slower economic growth during the financial crisis than what was predicted by the September 2008 CBO forecast. Let me make this point very, very clear. None of this was a result of problems with regulated futures and markets. I believe implementing the final rules promulgated pursuant to the Dodd-Frank Act will likely be the most important thing that I have done during my tenure at the CFTC. The financial crisis showed us that many of our financial regulatory systems were ill-prepared to effectively prevent the catastrophic loss of wealth this country suffered. For this reason, I believe that Dodd-Frank has correctly taken center stage in our efforts to ensure that events like this financial crisis of 2008 can be averted in the future. Unfortunately, there are times when a sideshow takes center stage. Position limits are, in my opinion, a sideshow that has unnecessarily diverted human and fiscal resources away from actions to prevent another financial crisis. To be clear, no one has proven that the looming specter of excessive speculation in the futures market we regulated even exists, let alone played any role whatsoever in the financial crisis of 2008. Even so, Congress has tasked the CFTC with preventing excessive speculation by imposing position limit. This is the law. The law is clear, and I will follow the law. However, as a commissioner at the CFTC, I think it's important to let the public know what may happen once we implement position limits. After we implement position limits, in all likelihood, the prices of heating oil and gasoline will not drop precipitously, as some have strongly suggested. Airline tickets will not be cheaper, and the food you buy at the grocery store will be the same price. Investments in precious metals will continue to rise and fall unpredictably. Things will remain relatively the same, except for those that use the markets we regulate to provide the very resources we all need. For these farmers, producers, manufacturers, position limits and the rules that go along with them may make it actually more difficult to hedge the risks that they take on in order to provide the public with milk, bread, and gas. The role of the future market is price discovery, not price setting. If we limit participation in these markets through position limits, producers may receive inaccurate market signals when making production decisions. If this occurs, the prices we all pay for our groceries and to heat our homes may become more volatile. Position limits may actually lead to higher prices for commodities as we consume on a daily basis. Despite the fact that we have received 15,000 comment letters on position limits and had hundreds of meetings concerning the pros and cons of position limits and whether or not excessive speculation even exists, my opinion has not changed. I am still left with the conclusion that no one has presented to this agency any reliable economic analysis to support either the contention that excessive speculation is affecting the market we regulate or that position limits will prevent the excessive speculation. Just in the last couple of weeks, Mr. Chairman, the Dallas Federal Reserve issued two papers in which they claim speculation did not have any impact on WTI, while at the same time, the St. Louis Fed issued a paper that said they did think, although it wasn't the most significant, it was a factor in the prices. I guess we're still in search for a one-armed economist, but we are seeing things on both sides, and there is legitimate debate on this particular issues. Maybe we ought to ask the Kansas City Fed to issue a paper, which will be the tiebreaker. As I said when we voted on the proposed rule, my fear is that position limits, at best, a cure for a disease that does not exist, or a placebo for one that does. At worst, position limits may harm the very markets we're intending to protect. I commend the staff for drafting a rule that will hopefully do as little harm to the market as possible. I know that the time and effort put into this rule may be greater than any other rule that comes before the Commission. It is unfortunate because it has taken the Commission's limited resources away from the issues that should be center stage, the important work of improving our financial regulatory structure to prevent another financial crisis. Among the rules that should take center stage for us in our rulemaking regarding derivatives clearing organizations that we will take up today. I take pride, and the industry should take pride, in noting that the regulatory system that we have in place for the futures industry works, and it worked during the 2008 financial crisis and its aftermath. The DCO rules we vote on today hopefully will bring a similar level of transparency and oversight to the swaps industry. And considering these rules, I am mindful of the excellent job that our clearinghouses have done in regards to the futures industry. And fashioning these rules, we should not be taking actions that places new restrictions on how they have always done their futures business. However, there are instances when our existing budget situation forces us to be prescriptive rather than principle-based in these rules. Unfortunately, the Commission simply does not have the resources to oversee everything that it would need to do to be a more principle-based regime. As a result, this rule is much more restrictive than it should be, in my opinion, if we had the necessary resources for oversight. Again, Mr. Chairman, I want to thank the staff for the hard work they've put into all three of these measures. I appreciate their effort in drafting the rules that should take the center stage in our effort to avoid and prepare for another financial crisis, but I especially appreciate their time and effort of meeting with me, my staff, in working out compromises that we have within these rules. Thank you.
I thank you, Commissioner Dunn, for those excellent remarks and the singing of happy birthday. Commissioner Summers.
Good morning. Thank you, Mr. Chairman, and thank you also to the teams that have worked so hard on the final rules before us today and also the amendments to the Commission's July 14th order relating to the effective date of swap regulation. The current order expires on December 31st of this year, and I'm glad we're addressing the necessary amendments to that order now instead of waiting until the last minute to provide the needed certainty to market participants. Today we will be voting on final rules for DCOs, and in my opinion, the rules are needlessly prescriptive and go beyond what is required by the statute. Our registered DCOs have a fantastic track record of protecting their own financial safety and soundness and have proven themselves, even during the financial crisis, to be excellent at managing margin and risk. We should allow them to continue to do so without imposing unnecessary and inflexible rules, regulations, and restrictions upon them. It appears that these rules and many others we have proposed and finalized are largely colored by the perception that swaps are inherently riskier than futures and options, and that as a result require a more prescriptive regulatory oversight regime. To that I say futures and options are and always have been risky. Swaps that are exchange traded and cleared will likely have a similar risk profile as exchange traded futures and options. We should not be creating a separate regulatory regime for economically equivalent products. I believe this approach will not stand the test of time and will have to be rethought as the market evolves. The fact that we are allowing letters of credit to be used as initial margin for futures and not for swaps is an example of this thinking, and is a distinction that is not legally or factually justifiable. We should treat them the same way unless there is a compelling reason not to. This is especially the case given the fact that today there are end users that voluntarily clear swaps using letters of credit as initial margin. Once we ban that practice, voluntary clearing will become more expensive for these end users and therefore less attractive to them. If we want to encourage clearing, which I think was one of our goals, we should not be taking steps to make clearing less attractive to those who are not required to do it. It has been nearly 2 years since the Commission issued its January 2010 proposal to impose position limits on a small group of energy contracts. Since then, Commission staff and the Commission itself has spent an enormous amount of time on the issue of imposing speculative limits. For me, this vote today on position limits is no doubt the single most significant vote I have taken since becoming a commissioner. It's not because imposing position limits will fundamentally change the way U.S. markets operate, but because I believe this agency is setting itself up for an enormous failure. As I have said in the past, position limits can be an important tool for regulators. I have been clear that I am not philosophically opposed to position limits. After all, this agency has set limits in certain markets for many years. However, I have had concerns all along about the particular application of the limits in this rule, compounded by the unnecessary narrowing of the bona fide hedge exemptions beyond what was required by the Dodd-Frank Act. Over the last 4 years, many have argued for position limits with such fervor and zeal, believing them to be a panacea for everything. Just this past week, the Commission has been bombarded by a letter-writing campaign suggesting that the 5 of us have the power to end world hunger by imposing position limits on agricultural commodities. This latest campaign exemplifies my ongoing concern and may result in damaging the credibility of this agency. I do not believe position limits will control prices or market volatility, and I fear that this Commission will be blamed when this final rule does not lower food or energy costs. I am disappointed at this unfortunate circumstance because while the Commission's mission is to protect market users and the public from fraud, manipulation, abusive practices, and systemic risk related to derivatives that are subject to the Commodity Exchange Act, and to foster open, competitive, and financially sound markets, nowhere in our mission is it our responsibility or mandate to control prices. When analyzing the potential impact this rule will have on market participants, I am most concerned about the effect on bona fide hedgers, that is, the producers, processors, manufacturers, handlers, and users of physical commodities. This rule will make hedging more difficult, more costly, and less efficient, all of which ironically can result in increased costs for consumers. Currently, the Commission sets and administers position limits and exemptions for 9 agricultural commodities. Pursuant to this final rule, the Commission will set and administer position limits and exemptions for 28 reference contracts. Along with the 19 new reference contracts comes the new responsibility to administer bona fide hedging exemptions for the transactions of massive global corporate conglomerates that on a daily basis produce, process, handle, store, transport, and use physical commodities in their extremely complex logistical operations. Their hedging strategies are no doubt equally complex. At the very time the Commission is taking on this new responsibility, the Commission is eliminating a valuable source of flexibility that has been a part of Regulation 1.3Z for decades. That is, the ability to recognize non-enumerated hedge transactions and positions. This final rule abandons important and long-standing Commission precedent without justification or reasoned explanation by merely stating the Commission has expanded the list of enumerated hedges. The Commission also seems to be saying that we no longer need the flexibility to allow for non-enumerated hedge transactions and positions because one can seek interpretive guidance pursuant to Commission Regulation 140.99 on whether a transaction or class of transactions qualifies as a bona fide hedge, or they can petition the Commission to amend the list of enumerated transactions. These processes are cold comfort. There is no way to tell how long interpretive guidance will take. Moreover, if a market participant petitions the Commission to amend the list of enumerated transactions, if the Commission chooses to do so, it must formally propose the amendment pursuant to APA notice and comment. As we all know too well, that is a time-consuming process fraught with delay and uncertainty. In the end, neither of these processes is flexible or useful to the needs of hedgers in a complex global marketplace. When the Commission first recognized the need to allow for non-enumerated hedges in 1977, the Commission stated, "The purpose of the proposed provision was to provide flexibility in application of the general definition and to avoid an extensive specialized listing of enumerated bona fide hedging transactions and positions." Today, the global marketplace is much more complex than it was in 1977, as are complex hedging strategies. I'm not comfortable with the notion that a list of 8 bona fide hedging transactions in this rule is sufficiently extensive and specialized enough to cover the complex needs of today's bona fide hedgers. Repealing the ability to recognize non-enumerated hedge transactions and positions is a mistake, and the statute does not require it. For decades, the Act has allowed the Commission to define bona fide hedging transactions and positions to permit producers, purchasers, sellers, middlemen, and users of a commodity or product derived therefrom to hedge their legitimate anticipated business needs. This provision is in Section 4A.C.1. In addition, Section 4A.C.2 clearly recognizes the need for anticipatory hedging by using the word anticipates in 3 different places. Nonetheless, without defining what constitutes merchandising, the Commission has limited anticipated merchandising hedging to transactions not larger than current or anticipated unfilled storage capacity. It appears then that merchandising does not include the varying activities of producers, purchasers, sellers, middlemen, and users of a commodity as contemplated by 4AC1, but merely consists of storing a commodity. This limited approach is needlessly at odds with the statute and with the legitimate needs of hedgers. I have always believed that there was a right way and a wrong way for us to move forward on position limits. Unfortunately, I believe we have chosen to go way beyond what is in the statute, and we have created a very complicated regulation that has the potential to irreparably harm these markets. I want to thank the teams again today for all your hard work on both the DCO final rules and on the position limit rules, and I look forward to the questions.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I'm going to date myself yet again. Remember the old television show, Starsky and Hutch? There was the informant, the narc, Huggy Bear, and he used to say, I'm going to lay it out so y'all can play it out. I'm going to lay it out so you can play it out. And that's sort of like what Congress has done with the law. They lay it out, and the regulators put the serious and deliberate meat on the bones, and they play it out. And we've been doing that since July of 2010. It's a process we go through. I believe that we are within the 4 corners of the law, that we are precisely in the middle, and we are doing what Congress instructed us to do. It's an uncommon rule. It's not going to please everybody. I'm not pleased with all of it. I have many of the same concerns that Commissioner Summers was just talking about with regard to anticipatory hedging, and we'll talk about that when we get to the position limit rule. But overall, I think this is a really needed, important piece of legislation or piece of regulation that's going to make this markets more effective and more efficient and devoid of fraud, abuse, and importantly, manipulation. There's 3 takeaways for me in the position limit rule. One is that for the first time in metals and in energy, we're going to have mandatory hard cap limits, federally established limits. Now, you can argue about the studies, and you can talk about that for a long time, but here's what I know. We've seen 30, 35, 40% of a market controlled by one entity, upwards of 40% at times. It's not theoretical, in my view, whether or not that can manipulate markets. I've seen it. It can happen. With this rule, that will end. The second thing is we're going to get rid of sort of the wild west of exemptions. You know, we gave that responsibility years ago to the exchanges, and instead we're going to take on that responsibility. The Commission will approve exemptions, but only under very strict guidelines. It's an old Bruce Springsteen song, you've got to prove it all night. So traders will have to prove that they are bona fide hedgers, that they have a legitimate business risk every day. The requirement will be that they tell us every month, but they will have to prove it all night and all day, that they need this for legitimate business purposes, that they're not involved in excessive speculation. Excessive speculation. We all know we need speculation in the market. Excessive speculation. And the third thing, and this is really the historic part of this, is that we finally cover what the chairman and what Commissioner Dunn talked about, and that is the swaps market, the dark over-the-counter markets that in fact were part and parcel to the economic meltdown that my colleagues discussed. One final area, and that is the limit levels. if any one of us were writing this, we would write it differently. I would write the limit levels more strict in certain cases, definitely with regard to precious metals. However, what we are doing, and people I hope don't underestimate the importance of this, is that we are setting up a position limit regime. It will be systematic. It will be part of what we do. Those limit levels will be identical across the board at first. That's the 10% in contracts up to 25,000, and then there's an added multiplier for the larger contracts. But the rule also requires that the Commission reassess and recalibrate as we deem appropriate. In my view, we should be doing that very often. These markets are changing rapidly, and I hope that at the very least, and I'll say it today, that next year, when we look at the swaps limits, that we also reassess the limits on the regulated exchanges. So I thank my colleagues for their help on this, even though there are, I think, some that have concerns. Commissioner Summers, I know Commissioner O'Malley has some concerns. But what may not go noticed a lot is that they still have had a big impact. I know Commissioner O'Malley had some early on changes. Commissioner Summers and I were working over the last several days, and even though she still has concerns, she's made some improvements to this. The chairman and Commissioner Dunn and I have worked tirelessly on this over the weekend, and I thank you all. I also thank my staff, in particular Elizabeth Ritter, who this rule wouldn't be anywhere close to that, Steve Sheridan, Dan Berkovitz. And finally, I want to thank the people who did comment, the 13,000 people who commented. When you comment, it's not a vote. We don't just do whatever the most votes say. But having those comments has been particularly helpful on this rule. And even in the last week, the 823 emails that we received. No, we don't control prices. We're not a price controlling agency. But we do want to make sure these markets are fair. There's a level playing field. And these folks have told us to make the markets fair. They've told us how they want us to play it out. Thank you.
Thank you, Commissioner Chilton. Commissioner Amaya.
Thank you, Mr. Chairman. Happy birthday.
Thank you.
Well, thank you to the staff for their hard work. The Commission is voting on final rulemakings on position limits and derivative clearing organization core principles. Further, the Commission will be voting on the exemptive relief during the pendency of the Commission rulemaking. Before we begin, I'd like to join my colleagues in thanking the three teams. I know they've worked tirelessly. The position limit rule has been here in the works since I've arrived at this Commission nearly 2 years ago. So I believe that they are probably very relieved to have this behind them. Their work has resulted in comprehensive documents totaling nearly 800 pages. Their perseverance over the past 2 years, nearly 2 years, has been truly inspiring. The position limit rulemaking will form the foundation of the Commission's surveillance of physical commodity markets. The DCO core principle rulemaking will form the foundation of the Commission's oversight of the financial integrity of market transactions. However, I'm disappointed with both rulemakings because they rely on fundamentally flawed assumptions, namely that the government knows best and has substituted its judgment for that of the exchanges and DCOs despite the complexities of the futures and now swaps markets. In my opinion, such assumptions will lead to regulations with substantial costs and uncertain benefits. These assumptions are very difficult to justify on an evidentiary and statutory perspective. First, both rulemakings have a substantial economic impact on the market participants for whom they rely on these commercial and legitimate reasons to use swaps and futures markets for their hedging purposes. Both rulemakings have been confirmed by the Office of Management and Budget to be major rules under the Congressional Review Act. This means that OMB has determined that each rule will have an annual impact of no less than $100 million. This determination is not surprising given the position rulemaking alone will force commercial hedgers to invest multiple millions of dollars in developing compliance systems just to account for their legitimate hedging strategies. Neither the position limit rulemaking nor the DCO rulemaking will fully describe its costs, even qualitatively, in its cost-benefit analysis. Further, neither rulemaking attempts meaningful quantification of its costs. Both rulemakings deprive the public of transparency into their impact in direct contradiction to two executive orders and make themselves vulnerable to legal challenge. The two quotes that best capture my views on cost-benefit analysis are from the President himself. He said in his executive order affecting this agency, quote, "Wise regulation decisions depend on a public participation and on careful analysis of the likely consequences of regulation. Such decisions are informed and improved by allowing interested members of the public to have a meaningful opportunity to participate in the rulemaking, and to the extent permitted by law, such decisions should be made only after consideration of their costs and benefit, both quantitative and qualitative." Second quote is from his recent rulemaking or his recent decision on the ambient air quality. It's, quote, "I have continued to underscore the importance of reducing regulatory burdens and regulatory uncertainty, particularly as our economy recovers." I notice he didn't say minimizing, or he said reducing regulatory burdens. And I think both of these rules go in the opposite direction. Obviously, it is a challenge to balance the regulatory objectives of the Dodd-Frank Act with economic growth, but the Commission has an obligation not to lose sight of the economic impacts to our economy. By not providing meaningful quantification, especially when we can easily do so, our cost-benefit analyses are inadequate by the President's own standards. Second, in addition to failing to detail costs, the two final rulemakings fail to articulate a convincing rationale for eliminating the current regime of a principles-based regulation and substituting a prescriptive government knows best regime. I recently celebrated my second anniversary serving as a commissioner of the Commodity Futures Trading Commission. Like my colleagues, I take this responsibility very seriously and am honored to serve. I recognize there are passionate views on both sides, especially with regard to position limits. But our role is to make decisions on policy in a dispassionate manner rooted in the facts. I hope that we will continue to examine the facts and ask tough questions as to the implications of each and every rulemaking. I've had several concerns with both the position limit and the DCO rulemaking. I've articulated my concerns in a separate comprehensive dissent, which will be available on my commission website after the vote, and I will have ask that be published in the the Federal Register. Old habits die hard. Let me briefly address my concerns with each of the rules today. Today's position limit rule represents Commission's desire to check the box on position limits. Unfortunately, in its exuberance and attempt to justify doing so, the Commission has overreached its interpretation in its statutory mandate to set position limits. While I do not disagree that the Commission has been directed to impose limits as appropriate, the Commission does not provide a legally sound, comprehensively rational basis on empirical evidence for a final rule that we will likely pass today. If the commercial entities who use futures and swaps for hedging feel like we are waging war on them, I don't blame them. According to the Commission's cost-benefit analysis, legitimate hedgers will pay close to a third of the annual cost of $100 million just for reporting alone. These are market participants for which Congress extended specific protection for their commercial hedging purposes, yet the rulemaking will increase the cost of hedging and managing their risk. For some, the new regulatory regime may be challenging, but I have no doubt that index investors and other passive long investors will continue to be able to secure their commodity exposure through new regulatory loopholes that we've yet to conceive of in our government knows best mandates, including possibly expanding their investments into physical stocks. This is not what Congress intended. And as I have said before, the data backing up the effectiveness of position limits on agriculture products over the last several years just doesn't hold water. These commodities have experienced volatile markets and high prices. And obviously, as all of my colleagues have said, we're not a price-setting agencies, and nor will these position limits affect those. The DCO core principle final rulemaking is among the most important of the Dodd-Frank rulemakings, in my opinion, and that the Commission has undertaken. I've been a strong proponent of clearing, and I am certain that clearing will benefit the swaps market, and in particular benefit the buy-side firms that will have access to the same beneficial opportunities enjoyed by dealer firms. However, I disagree with the prescriptive approach of this final rulemaking because it leaves DCOs with insufficient discretion to take legitimate action to manage the risk they confront. Two provisions in particular best highlight these concerns. In the final rulemaking, it prohibits a DCO from requiring more than $50 million in capital from any entity seeking to become a swaps dealer. The number makes a great headline. Unfortunately, it appears to lack evidentiary basis. Moreover, where the $50 million threshold may prevent a DCO from engaging in anti-competitive behavior, it may also prohibit a DCO from taking a range of legitimate risk-reducing actions. For example, increasing capital requirements proportionate to risk. This final rulemaking provides little to no insight in the manner in which the Commission intends to distinguish its priorities in setting legitimate risk rules, including default fund management, guarantee fund levels, and margin requirements. Let me be clear. I am against anti-competitive behavior. However, an entity with a $50 million in capitalization may not be the appropriate clearing member for every DCO. The Commission should have provided a principles-based guidance to DCOs on their components of fair and open access, such as the standard for less restrictive participation requirements. This would have also put the Commission in greater accord with its international colleagues and regulators. The other concern I have is the rulemaking. It also requires a DCO to calculate margin using different minimum liquidation times for different products. Specifically, a DCO must calculate margin for futures based on a minimum of 1-day margin liquidation, agriculture, energy, and metals swaps based on a 1-day margin liquidation time, and all of the swaps based on a 5-day liquidation time frame. As a preliminary matter, such minimum liquidation times appear to lack any evidentiary basis. More importantly, when these requirements are juxtaposed to our proposal interpreting Core Principle 9 for designated contract markets, it becomes clear that the requirements have the potential to severely disrupt established futures markets. According to the proposal, a DCM may convert delisted futures contracts into swaps contracts. However, if the futures contract references financial commodities, then this rulemaking would require a DCO to margin such swap contracts using a minimum liquidation time of 5 days instead of 1 day for futures. If nothing substantive about the contract changes other than the characterization, then how can the Commission justify such a substantial increase in minimum liquidation time and margin? Again, the Commission should have retained the principles-based regime and should have permitted each DCO to determine the appropriate liquidation time for its products based on a risk-based analysis. Determining an appropriate margin requirement involves quantitative and qualitative expertise. Such expertise resides at the DCO and not at the Commission. It is a cost-benefit analysis that the final rulemaking admits, and the final rulemaking admits as much. Returning to a principles-based regime would have better aligned us with international regulators on this matter as well. Finally, let me mention a brief comment about the effective order. As Yogi Berra famously proclaimed, it's deja vu all over again, and that encapsulates my feelings today. I support the proposal as I did the last time because it's important that the Commission provide the market participants and the public with a form of relief the exemptive order is contemplating. But I would have preferred this rule, like its predecessor, to not have selected an arbitrary end date. Mr. Chairman, I again renew my call for a comprehensive implementation plan that provides greater insight into the reporting requirements on swap data repositories, as well as separate rulemakings on real-time and block rules. The Commission must also provide some certainty on the clearing and trading mandates, including clarification of made available for trading and guidance on swap clearing. Now, Mr. Chairman, I am mindful that today is your birthday, and you're probably old enough to know that you don't get everything you want on your birthday. And I will be voting against both the position limits and the DCO core principles. Thank you.
Mindful, and I still want to chat with Macy about what you did give her on Christmas, but
she didn't get a towel rack.
I know she didn't get a towel rack. And we've been working pretty well together, Commissioner O'Malley, even though we have some fun in public about sometimes that we don't see eye to eye. And I think there's a lot in these rules that have benefited from your advocacy and your input, and as well as Commissioner Summers. But I'm just addressing you as much as anything because you've really been into engaging in these rules, even though you're not supporting them today. So I thank you. With that, I think that the staff will make presentations concerning the recommendations on final rule implementation. As we mentioned, we're going to start with some of the members from our General Counsel's office, General Counsel Berkowitz, Mark Higgins, Terry Arbit. It's good to see you again. I suspect we'll see you many more times. But to take up further relief under an exemptive order, which would be, if we voted out today, proposed, and we'd seek public comment and seek to finalize it before the end of the year. But I think Mr. Berkowitz. I'm sorry. I'm supposed to ask unanimous consent that all final votes conducted at the meeting will be recorded votes and the results published in the Federal Register. It's so being done.
Thank you, Mr. Chairman. For the presentation this morning, I'll turn it over to Mark Higgins in our office.
Happy birthday, Mr. Chairman, and good morning, Commissioners. On July 14, 2011, pursuant to the authority provided for in Dodd-Frank Act Section 712F and Section 4C of the CEA, the Commission issued an order granting, in two parts, temporary exemptive relief from certain provisions of Title VII of the Dodd-Frank Act. First, the Commission provided relief from certain provisions of the CEA added or amended by the Dodd-Frank Act that do not require a rulemaking but that do reference one or more of the terms regarding swap entities or instruments that the Dodd-Frank Act requires be further defined. Such terms include swap, swap dealer, major swap participant, and eligible contract participant. The Commission, jointly with the SEC, has issued two notices of proposed rulemaking to further define these terms. But because these final rulemakings were not expected to be in place as of July 16, 2011, the Commission temporarily exempted entities from complying with these provisions until the earlier of the effective date of the definitional rulemakings for such terms, or December 31, 2011. The second part of the relief, the Commission provided relief from certain provisions of the CEA that may apply to certain agreements, contracts, and transactions in exempt or excluded commodities, generally financial, energy, and metal commodities, as a result of the repeal of various CEA exemptions and exclusions by the Dodd-Frank Act as of July 16, 2011. This exemption was based on the Commission's existing Part 35 exemption for swap agreements, but was made available for certain agreements, contracts, and transactions that may not otherwise have qualified under those rules, for example, if they are cleared. The Commission stated that this exemption was also temporary, expiring upon the earlier of the Commission's repeal or withdrawal of Part 35 or December 31, 2011. The notice of proposed amendment before you today would modify this relief in two ways. First, it would extend the outermost date of the relief from December 31, 2011 to July 16, 2012. Second, the proposed amendments would account for the repeal and replacement, as of December 31, 2011, of Part 35 of the Commission's regulations. In all other respects, the proposed amendments would maintain the status quo. As such, the notice seeks comment only on the proposed amendments. Before concluding, I would like to thank our Division of Market Oversight and Division of Clearing and Risk colleagues for their assistance, particularly DMOs David Van Wagner, Don Heitman, and Ryan Miller, as well as the Division of Clearing and Risks, Jody Partridge. We'd be happy to take your questions.
Thank you, Mr. Higgins and Dan and Terry. I think I'll entertain a motion to accept the staff recommendation on this proposed order, or amended order.
So moved.
Second.
I support the proposed amendment to the July 14th exemptive order. The order, as was just described, of course, provided relief until the end of this calendar year, or when the definitional rulemakings were effective. These are further definitions on entities, or what the public would think of as the swap dealers, and then on products, or many people, the public, it's swaps. And though Congress has been pretty explicit and detailed on those definitions, along with the SEC, the CFTC was to give further meaning to these words. I thought I would just mention that the Commission staff is working very closely with the Securities and Exchange Commission on these rules, and that staff is making great progress. We anticipate taking up the further definition on the entities, or swap dealers, in the very near term, product definition following behind it. I think, to my fellow commissioners, we're probably with, and I don't know where Mr. Karpoff is and the lawyers, Mr. Higgins, you're working on that one too. but somewhere in the next couple of weeks to get a document to you on the entity definition, and then we'll start to get more feedback. You, of course, will have comment summaries, so to the extent you have feedback based on those comment summaries, that would be enormously helpful to staff, particularly as they're negotiating across the two agencies. That would be very helpful. I think the comment summaries on products will come shortly thereafter. Maybe in the next 2 weeks you'll get the product summary comments, which will then help us move along each of those. As these definitional rulemakings have to be finalized and become effective, today's proposed amendment would provide relief through July 16th, or when the definitional rulemakings will become effective. But I do think that that gives us sufficient time, given that we'll have a document, a pens-down version on the entity shortly, and the comment summary on products pretty shortly as well, and then move after that. In addition to today's amendment clarifies by kicking it out to July 16th. It also tailors the July 14th amendment in light of the Commission's actions on agricultural swaps. I understand that we revoked Part 35, and so we have to have a reference at least till July 16th on it. So unless I've said something you find inaccurate, I support the proposal. I look forward to public comment as well, but I turn it over to Commissioner Dunn for any questions.
Thank you, Mr. Chairman. This action today, to me, is a painful and embarrassing reminder that we still do not have definitions. And I know that you have worked hard to try to get those out, but here we are expanding the timeline simply because we don't know what we talk about. And this has probably been the greatest concern that I've heard from industry as a whole, that tell us what we are, tell us what the products are. And I'm hopeful that there doesn't have to be another extension on this. Mark, just a couple of questions. How does the proposed order change the nature or scope of the existing relief provided on July 14th?
It does not.
That's what I was hoping to hear. Does the order provide an assurance of finality in regard to when the Commission's final rule establishing a new swaps regulatory regime will be finished, and how?
It does not.
Thank you.
Thank you. Commissioner Dunn, if I might mention, Congress was pretty specific on what is a swap dealer and what is a swap, and I don't think there's much debate about what a 5-year interest rate swap is, for instance. But what we benefited by in this definitional process is we did, as you recall, an ANPR. That's where we asked the public for comments before we even do rulemaking. We did some public roundtables with the SEC, particularly on the swap dealer definition. And then we did 2 proposals and got very detailed comments. And it's, of course, everybody wants their very specific and unique question answered, but most of the questions on products relates to the forward exclusion, which we've had for decades, and I think all of us, while there's some differences in the substance, have taken to heart Congress's intent that forwards are not futures and forwards are not swaps, and then it just gets around that. Some really excellent comments that have come in to ensure the public in the agricultural markets and in the energy and metals markets, producers and merchants and so forth, if they're entering into forwards, that's not going to get caught up in this thing. So it's taken some time just to make sure that we react to responsively all of the comments, as well as on the swap dealer definition, which is similar. The swap dealer side is also a lot about commercial parties not getting caught up in this thing.
Mr. Chairman, I don't take issue with the benefit we're getting from getting public comments on this. What I take issue with is drawing this out in the timeline and trying to get some certainty out there so that people know what they're talking about. I grant you that there are a lot of them know who they are and what they deal, but until they see it in rule, Hope springs eternal.
Nothing would please me more than to bring it to you the next meeting. I think we're pretty close on the entity definition one. So, Commissioner Summers.
I just have one question with regard to the end date. So what needs to be accomplished between now and then to make sure that we don't have to extend this again?
Right. So for Part 1, it would be the further definition and rulemakings that reference that. And then for Part 2, it's coterminous with the expiration provided for in Dodd-Frank for the grandfather relief provisions 2H and 5D.
Thank you, Commissioner Summers. Commissioner Chilton.
I just wanted to briefly try to explain this in layperson's terms, and the lawyers can tell me if I've got it wrong, because last time we did this, received some criticism from people who thought we were sort of cutting out the responsibility from market participants to comply with the Dodd-Frank law. Until we do what I termed earlier, putting the meat on the bones of the law, until we do that, there's really nothing for folks to comply with. They don't know if they fit into the definitions. They don't know what exactly they're supposed to do. They just have the general skeleton of the law as Congress laid it out for us. So we have to do the rules in order to give them something to comply with. I agree with Commissioner Dunn. I wish we'd done a lot of this before. On the other hand, we want to be thoughtful. We want to make sure that we're getting it right. So that's why, we have to do this again. I'm disappointed on one hand. On the other hand, I think people should take some comfort in the fact that we're trying to be deliberate. So have I misstated anything, Mr. Berkovitz?
No, Commissioner Chilton, I think you've correctly stated. I would add just an expansion of the point that you've made, that the order also provides that with respect to any rulemaking that the Commission shall issue during this period, if the Commission in that rulemaking makes that provision effective, then that provision will become effective prior to the expiration. So as the Commission, it anticipates that as the Commission does rulemakings during this period, the Commission may make those rulemakings effective.
So if we pass position limits today, then it gets implemented in accordance with that rule, and the same with other rules.
It would be in the individual rulemaking. The position limits rule, as we'll explain later, does have its own effective date.
That's a very helpful clarification. I thank you for it. Thank you, Mr. Chairman.
Yeah, I think it is a helpful clarification, because the 11 rules we finalized this summer in public meetings, and we finalized another by seriatim, so I'll call it the 12, have their individual effective dates, and to like swap data repositories they can register already. For instance, large trader reporting has some dependency on the further definitions, but where it doesn't, where it's a clearinghouse or futures commission merchant, they could already be providing information. Is that correct?
That is correct, Mr. Chairman.
Or the Forex, of course, which we finalized in 2010 earlier. Is that right?
Yes, that is correct.
Commissioner Amalia?
I don't have a question. I've asked that we have some certainty, I think, like Commissioner Dunn, and we just eliminate the artificial date and just go with when the rules are effective. And it sounds like there's consensus on that. So maybe I should quickly draft up an amendment here to swap that out. But
there's not consensus on that.
Hope springs eternal. So I have no comment, but I just hope that we won't have to revisit this yet.
I know what we have consensus on is to finalize the further definitions of swap dealer and further definition of swap. That is a lot of consensus here. I mean, we'll get into the details, and I think you'll be very pleased with the staff work. It's consistent with the comment summary that you have on the entity definition, as I've seen it. So.
Well, that will be an interesting debate and a very good debate. We might even fill the room again, because that is for all the marbles. And we have different rulemakings out there. The Volcker rule has different entity definitions, and we're going to have we're debating different definitions. So this will be a great one to have. I can't wait for it.
Great. I think Mr. Staywick, if you want to call the roll.
Commissioner O'Malia?
Aye.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this matter, the yeas are 5, the nays are 0.
I guess the ayes have it, and the staff recommendation is accepted, and we'll be sending it out to the Federal Register for comment. Thank you very much, and Ananda and others in the team. It's a big team, John Lawton, and I gather Phyllis is on. She's not physically here. Is that right? But we'll give members of the public, we're going to give a minute to just allow the next group to get up to the stage. We're going to welcome John Lawton, Ann Pulaski, and Ananda Radhakrishnan, all of the Division of Clearing and Risk, to present the staff recommendations regarding the final rule on derivative clearing organization general provisions of core principles. These are primarily related to the financial risk management and risk oversight of the clearing organizations, but take up other critical matters as well.
Thank you. Do you want me to wait for Commissioner Dunn?
Yeah, why don't you wait? It might just be a minute. That'd be fine. Thank you. Ananda, I think we're going to...
Okay.
Okay.
Good morning, and we're going to present the final rules for to implement.
Do you want to just move the mic a little closer to you?
Present final rules to implement a significant portion of the DCO core principles. Before I do that, I'd like to recognize the dedicated members of the team from DCR who worked on this. John Lawton, Deputy Director. Phyllis Dietz is away on vacation in Japan, but she has promised to try and get into the webcast. It's like close to 12 o'clock in the morning in Japan, but being the tireless and dedicated civil servant that she is, instead of enjoying herself in Japan, she is watching this webcast. Ann Pulaski, who's special counsel from the Chicago office, and I'll mention other people: Eileen Donovan, Jake Prazarovich, Jonathan Lave, Julie Moore, Tom Kaprowski, Susan Reyes, Steve Kreska, Kenji Takaki, and Harry Rao. So I thank my team, and I'm going to hand it over to John. I'm sorry, Ann's going to go first. Sorry.
Good morning, Mr. Chairman, Commissioners.
You might, and then if Ananda, you hit yours, so there's not feedback. Thank you so much.
My comments will provide a brief general overview of this rulemaking, and then John Lawton will discuss the major issues. The rules would implement 15 DCO core principles: compliance, financial resources, participant and product eligibility, risk management, settlement procedures, treatment of funds, default rules and procedures, rule enforcement, system safeguards, reporting, record keeping, public information, information sharing, antitrust considerations, and legal risk. In addition, the rules would update and add related definitions, address DCO chief compliance officers, and revise procedures for DCO applications, including the required use of a new form DCO. The rules were proposed in 5 separate notices of proposed rulemaking. The Commission received a total of approximately 119 comment letters addressing these proposed rules. The Chairman and Commissioners, as well as staff, participated in numerous meetings with representatives of DCOs, FCMs, trade associations, public interest groups, traders, and other interested parties. In addition, staff has consulted with other U.S. financial regulators, including the Federal Reserve Board and the SEC, as well as foreign regulators. Many of the rules would be adopted as proposed, although there are a number of provisions that have been revised or eliminated upon further consideration in light of the comments received. The rules are designed to strike an appropriate balance between establishing general prudential standards and specific requirements. The rules also reflect a careful consideration of the costs and benefits associated with each rule. Now I'll turn it over to John.
Morning. I won't go through all 15 core principles addressed in this rulemaking, but instead highlight about a half dozen of the more prominent provisions. First, financial resources. The final rule would require each DCO to maintain sufficient financial resources to enable the DCO to meet its financial obligations to its clearing members, notwithstanding the default by the clearing member creating the largest financial exposure in extreme but plausible market conditions. This is the so-called Cover 1 standard. It is the standard set forth in Section 5BC of the Act. You will recall that in addition to proposing the Cover 1 standard as a baseline for all DCOs, the Commission had also proposed a Cover 2 standard for those DCOs designated as systemically important by the Financial Stability Oversight Council, or FSOC. Because the FSOC has not yet designated any DCOs as systemically important, and because international standards in this area have not yet been finalized, staff believes that it would be premature to finalize this or any of the other rules relating to SIDCOs at this time, so that's not in this particular package. The next prominent issue is participant eligibility. The final rule would state that a DCO may not set a minimum capital requirement of more than $50 million for clearing members. This provision is intended to permit more firms to be eligible to become clearing members in furtherance of the congressional mandate of fair and open access. The rule should increase competition for clearing services, thereby reducing costs, and it should reduce concentration, thereby reducing systemic risk. As a risk management tool, the rules also would require DCOs to set scalable limits for their clearing members in accordance with the financial resources of each clearing firm. Moving now to margin, an important issue is the liquidation time horizon to be used in setting margin requirements. The final rules would provide that DCOs should set a liquidation time that is at least 1 day for futures, at least 1 day for swaps on agricultural products, energy products, and metals, and at least 5 days for swaps on financial products. The rule also provides a safety valve permitting the Commission by order to establish either a longer or a shorter time for particular products. The times set forth in the rule reflect current practices at DCOs. The rule provides legal certainty for the evolving marketplace as well as a practical means for assuring that thousands of swaps subject to the Commission's oversight will have prudent minimum margin liquidation time horizons. In addition, it will prevent a potential race to the bottom by DCOs that might be tempted to compete by lowering margin requirements. Also in the area of margin, the rules would require DCOs to collect margin from their clearing members for customer accounts on a gross basis. For those DCOs that do not already collect on a gross basis, this will increase the amount of margin at the clearing level, thereby reducing the risk that a clearing member will default to the DCO. In order to reduce potential operational and technology development costs that commenters mentioned in the comment period, the final rule would permit DCOs to collect the sum of a clearing member's gross customer positions without necessarily breaking it down by individual account. The last prominent margin-related issue is the use of letters of credit as initial margin. The rule would permit their use for futures, but not for swaps. Unlike other margin assets, letters of credit are a promise to pay, not an asset that can be sold. Thus, they pose different risks than the other types of margin assets currently collected. A number of commenters stated that letters of credit, however, have been used for some time in the futures markets without incident. In order to avoid disrupting current practice, the rule would, in a sense, grandfather letters of credit for futures while establishing a more cautious standard for the potentially larger swap market. Finally, I should mention that the rules would provide for staggered effective dates. I won't go through all the provisions, but note that most of the rules would be subject to a 60-day effective date, but some would be subject to a 6-month or 1-year time frame. For example, the letter of credit provision would be effective in 6 months, while the gross margin provision would be effective in 1 year. And that concludes the presentation. Thank you.
Thank you, Mr. Lawton. I look for a motion on the staff recommendation on core principle final rules, clearinghouse core principle rules.
So moved.
Second.
Thank you. I support the final rulemaking. I think this is one of the most significant rulemakings to help lower risk in the financial system. Clearinghouses that have existed since the late 19th century have functioned both in clear skies and during stormy times. They've, of course, functioned in the futures marketplace. And this agency, I think, has a proud history of regulating those clearinghouses through the Great Depression and numerous bank failures. I guess we weren't regulating it during the Great Depression, but through numerous bank failures, a world war, and of course the 2008 financial crisis to help lower risk to the economy. And importantly, centralized clearing protects the dealers, usually the banks, and their customers from the risk of either party failing. So when one customer doesn't clear their transactions, they actually take on the dealer's credit risk. So uncleared transactions taking on a credit risk, cleared transactions then has the risk reduction side in a clearinghouse. And we have seen over the decades that banks and dealers do fail. Centralized clearing protects all market participants, requiring the daily mark-to-market valuations and requiring collateral to be posted. These two fundamental features: value the transactions daily and putting up the daily valuations, which has worked so well in the futures industry these many decades. But it does protect the counterparties or customers, the corporate end user, the farmer, the merchant, in case a bank fails. And of course it protects banks in case other banks fail or dealers fails. It lowers the interconnectedness between financial entities that help spread risk throughout the economy in 2008. Any wonder about this is just think about AIG and how many uncollateralized swaps they had between them and other parties. So then that turns me to today's rulemaking and why I support it. I think it establishes certain regulatory requirements for the clearinghouses to implement their core principles. And we recognize the need for very robust risk management standards, particularly as more swaps come in. Dodd-Frank says there's a mandate. And that mandate might cover much of a $300 trillion marketplace moved into clearinghouses. And throughout this great debate over these last 2 years, there's been many an editorial and many a news story about, are we just moving systemic risk from the banks to the clearinghouses? That's why this rule that we look to today is so important. And yes, that's why, Commissioner O'Malley, that I think it's important that we are prescriptive, because safety and soundness cannot be a race to the bottom between clearinghouses picking and choosing their risk management standards. I think they should compete on service and price, and there's many, many things to compete on, but there is a risk if they compete on lowering standards in a competitive environment. So what did we look to? We looked to international standards. They're called the IOSCO and CPSS standards. These are just acronyms for international organizations that have come together. And what we put in the final rule, based on much public comment, is that the financial resources and risk management requirements will strengthen the integrity and also enhance legal certainty of these clearinghouses. We've adopted a requirement that the clearinghouse collect initial margin on a gross basis for its clearing members' customer accounts. And we have, as Commissioner O'Malley pointed out, and the staff pointed out, differentiated that for interest rate and financial index swaps, credit default swaps in essence, the index swaps, we are maintaining as proposed, a minimum liquidation period of 5 days. That means if somebody defaults, you have to have some margin to cover a 5-day liquidation. This happens to be consistent with current market practice. And in fact, we got many comment letters to say, keep this in place, from industry associations as well as large banks and as well as the largest interest rate clearinghouse itself today. We also got comments from the central banks themselves, from the U.S. Federal Reserve directly to me in the most senior way they can. Do not please lower this 5-day. And from the Bank of England as recently as meetings last Thursday that I had. They are very focused on that interest rate swaps are at the center of the swap market, some 80% of the market, and it's where bank-to-bank risk is most fundamental. We have taken the view on the physical commodity swaps, such as energy, metals, and agricultural swaps, which is a far smaller part of the market, and by the way, has a market practice here in the U.S. of one-day margining in swaps at two large clearinghouses, and has had one-day margining based on commission orders and practice. And there are many commenters that said we should lower the cost of our initial rule and go to one-day liquidation. As a safety valve and as flexibility, we've included that the clearinghouses can petition over time. And I accept Commissioner Summers' point of view that this may change over time. It may be that swaps become as liquid as futures. They're not there yet, but they may become as liquid as futures. And I think it is appropriate from time to time to have the Commission take a look at it, either by petition or by actually adjusting this rule through notice and comment. But for now, I think as we have this great paradigm shift, it's critical that we listen to the central banks around the globe, listen to the largest industry associations, and keep the interest rate swap liquidation period at 5 days. Period. In 2008, I do want to note for the public, it took 5 days to actually move the position of Lehman Brothers at LCH, which is in London and is the largest interest rate swap clearinghouse. That is relevant, at least for my thinking, as I looked at this and actually debated often with fellow commissioners this 1-day or 5-day margining. I think that our agency is a market regulator, but it's also a safety and soundness regulator, and critical as we look at the risk on the horizon, whether they're from Europe today or in the U.S. or elsewhere, that we go with the best practices that exist today. Second, the rulemaking implements Dodd-Frank's requirement on open access. Participant eligibility requirements promote fair and open access to clearing and help democratize the marketplace. Importantly, the rule addresses how a futures commission merchant can become a member of a clearinghouse, and the rule promotes more inclusiveness while allowing a clearinghouse to scale members' participation. And I think this is quite critical. The clearinghouse will be able to scale participation by the amount of capital. So when this rule says a minimum of 50 million capital, somebody that has $1 billion of capital can be scaled to have a lot more risk in the clearinghouse. And we think that that is appropriate and prudent, but that clearinghouses have less risk if they're more inclusive. And that's certainly the model in the futures industry. I see John Damgard here, who heads the Futures Industry Association. But I do think that it's worked well in the futures industry to have a more inclusive model, and that's what this embodies Congress's will. There's reporting requirements as well that will help the Commission and the public with regard to clearinghouses, and the rule finalizes application procedures to have greater uniformity. I think overall the rules help lower risk to the system, and particularly the moving the swaps market into central clearing. But I don't know, Ananda and John and Ann, if you have anything to say on my little monologue there as to why I'm supporting this rule.
Just one more point. LCH, in addition to 5 days, it consumed 30% of the margin. And LCH...
You're saying on the Lehman Brothers situation.
So
But it's correct, Ananda, because you lived it. I know Bob Wasserman and others, and some of the commissioners were here at the time, 3 of my fellow commissioners, that it took till that Friday for them to actually move or deal with the Lehman Brothers interest rate swap positions.
That's what they told us.
Thank you. Commissioner Dunn.
Thank you, Mr. Chairman. And as I said in my opening statement, I really feel like we're moving into the center stage here, that these opening up the clearinghouses for the swaps certainly does get us into the area of providing a greater amount of openness, transparency, and safety in our financial regulatory programs. When we first started doing proposed rules, and I think it was probably the first meeting, I had directed folks to what I call the boilerplate section in the back of the regulations and pointed out the cost-benefit analysis. And I didn't know what type of Pandora box I was opening at that time, but that certainly has become a big issue on this rule and the next rule that we're going to take up. And will be a concern as we continue to go. And I really do appreciate those who have sent in comments and have pointed out their concerns about what the cost and benefits will be of these various rules. I know some of my colleagues are going to drill down on this, so I'm not going to spend much time there. Ananda, under Section 39.11, it permits any other financial resources deemed accessible by the Commission. The preamble to this rule states that the Commission could evaluate letters of credit on a case-by-case basis. Under what circumstances would the Commission make such an evaluation, and what criteria would be used in making such an evaluation?
I imagine that, and I'm just thinking out loud because I don't know what the DCOs will tell us, but if the DCOs can show that there has been a call on a letter of credit and the bank paid, that would give me a lot of assurance. The concern I have about letters of credit is that it's a promise to pay by a third party. It's not possession by the DCO of collateral that it could use unfettered. So the proposal before the Commission seeks not to disturb the current practice in the futures industry, and that's why it says it's fine for futures and not for swaps. But that is the concern. So perhaps if they showed that banks that are issuing the letters of credit have a history of paying, maybe not in the futures context, but in other contexts, the question is what assurance can they provide the staff and then eventually the Commission that if called upon, the bank will actually pay? I'm not talking about the contractual obligation. The letter of credit can be, completely airtight, right? And the letter of credit could say, I will pay and I'll pay within an hour. But promising to pay and actually paying are two different things.
Ananda, throughout the period, and Chairman Deb stepped out, but for him and his staff, I greatly appreciate their working with me, my staff, and my fellow commissioners on accepting changes to the rule from the initial proposal, and there were some, and it has been greatly improved. So I appreciate the hard work the staff did and the time and patience, Ananda, that you've spent in my office explaining to me.
No, it's my pleasure.
It didn't appear to be at the time.
I'm just a sourpuss guy. I just don't mind.
One of the things, a phrase that you've used to me over and over, and the chairman has repeated this morning, is a race to the bottom.
Mm-hmm.
And it occurs to me that working with a DCO is greatly different than looking at over-the-counter swaps or credit default swaps, for instance, because you have another entity that is at risk and a risk committee that are looking at things in there. Overall, and I've said early on that I thought we should be less prescriptive. This rule is much more prescriptive than I would like to see. I would hope during the future periods that we're able to get back to principle-based regulations in this arena. But is there a distrust that we have with the DCO that the monies that they've got at risk and all the members have at risk, that they're not going to be prudent and conscious and conscientious as they look at products and clearing members?
I wouldn't say that there's distrust. There's so far no DCO has done anything that has caused me or any members of my staff to distrust them. But I think if I could direct you to page 4 of page 4 and 5, where the document seeks to explain why we've chosen regulations, where we talk about increasing legal certainty for DCOs, clearing members, and market participants. And in case anybody is inclined to lower risk, it prevents them from lowering risk for competitive reasons or for taking on more risk than is prudent. The imposition of legally enforceable standards provides assurance to market participants and the public that DCOs are meeting minimum risk management standards. And this can serve to increase market confidence, which in turn can increase open interest and free up resources that market participants might otherwise hold in order to compensate for weaker DCO risk management. So I think the DCO rules are not just meant for the DCOs, but also meant for public consumption, because we may see a tremendous shift of activity from the current uncleared bilateral market, move to the cleared regulated markets. And we just want to make sure that the history that you've pointed out, Commissioner Dunn, about the record of the futures industry thus far of having no blemishes continues to do so.
I would also add that in a couple of instances, DCOs commented in favor of some of these prescriptive rules. So I think some DCOs at least have some concern that some of their competitors might, in fact, move in a different direction without them.
Because we have 16 DCOs now, and we might have more in the near future. And also, to John's point, a lot of these rules sort of codify current DCO practice. So, and therefore, we believe that most, if not all, DCOs should not have difficulty in complying.
In our conversations, the concept of codifying some of the current practices are, in fact, moving from a principle-based regime to a more prescriptive base.
Right.
And you and I have had numerous comments on this. And your final appeal to me always appeared to be, well, this is what we can do with the staff we have, and for us, in an overabundance of cautious, we feel like we have to have the final oversight on this, since we don't have the FTEs available, as full-time employees available to go out and conduct audits on compliance with the regulation. Could you amplify on that concern a bit?
Prior to having rules, you had principles which are fairly broad brush, and there's also the core principle A that says the DCO essentially has discretion in how it complies with the core principle. Which, if you're a DCO, is really nice, because you can say, I can pretty much do whatever I want. And so the question is, how does the regulator respond to that? And I think that in an environment where you don't have resources, you could potentially have a lot of time spent going back and forth between the CFTC staff and a DCO as to whether a DCO is in compliance with the core principle. A regulation is much more clear cut. You're either in compliance or you're not. We have 13 examination staff. That's woefully inadequate for 16 DCOs. We try and do the best job that we can, but, if somebody asks me whether we can examine all DCOs once a year, the answer is no. So, we hope that having regulations would make it easier for us. And the other issue is, how serious do we want to be taken as a regulator? I'd say very seriously. So, when things are going fine, everybody says, back off, get away, don't interfere with my business. But when things go wrong, the people suddenly start looking at us and saying, where were you? So,
you've made the comparison to me of some existing DCOs and what you see as new ones coming on. Do you contemplate differential supervision in the future?
By differential, do you mean would we spend more time? Yes, absolutely, because it's going to be a function of the amount of activity that a particular DCO undertakes. So, for example, not to pick on names, but when we examine the CME group or LCH or Ice Clear Credit, we would probably spend more time because of the sheer volume of activity that they undertake to make sure that we have a comprehensive understanding of their operations than we would with, say, a DCO that has not begun clearing, where the open interest is fairly small. It's just it's differential, it's risk-based, but that's how we operate.
I often tell people that there's no such thing as a final rule because this is a dynamic process, and we're going to be learning as we go along. In addition, folks that completely disagree with it can petition us to rewrite the regulation. If we're landing the airplane upside down, certainly the staff is going to say, wait a minute, we need a change here. There is a possibility for folks to go to Congress and get the legislation changed at all time. But we'll also, do you contemplate that as we begin to understand what we're doing here and the industry as a whole, do you anticipate that we'll be going to some guidance in lieu of some of the stricter prescriptive positions that we've taken?
I can't answer that because I don't know what our staffing will be. We might find that regulations work just fine because everybody likes, the bright line of a regulation. If you look at
they haven't contacted me yet.
Not surprised. But if you look at FCMs, for example, FCMs are not subject to principles. FCMs have been subject to the Commission's regulatory scheme, since the time the Commission was set up. And, FCMs will come and complain from time to time, but, it's very clear what an FCM has to do. So, is it possible? I guess, a future Commission may direct staff to say, I want you to go back to a more guidance approach, and the staff will do what the Commission tells it to do. But, I like regulations. I like a bright line because then I can tell somebody you're in compliance or you're not. So,
thank you very much. Thanks the entire team.
Thank you.
Thank you, Commissioner Dunn. Commissioner Summer.
Thank you, Mr. Chairman, and I have said already how much I appreciated all of your help and assistance on these rules. They're very complex and complicated. It's a huge amount of work that's gone into all of the proposals. And thank you to Phyllis, who's listening, for all of her help as well. She's put in a lot of long hours on these rules, so certainly thank you to Phyllis as well. I have a number of different areas where I'd like to ask a few questions, and the first one is on the Chief Compliance Officer. When we did the final rule on swap data repositories, we prohibited an SDR from having the general counsel or a member of the legal department from serving as a chief compliance officer due to the possible conflicts of interest. But the DCO rules allow members of the legal staff to serve as a CCO, which I, by the way, agree with. But can you explain what kind of thought process goes into this kind of discrepancy in our rulemaking? I mean, how is it okay for a DCO, but it's not okay for an SDR? I think, again, you did the right thing, but was there any sort of back and forth on this?
One thing was that there were some comments from some of the smaller DCOs that said it would be a staffing problem for them and that they didn't really have big enough staff. And so I think the potential distinction was that there may be potentially fewer SDRs, and they may, in fact, have larger staffs to start with. So, and again, I'm not familiar with the comment that were received in that case, but I do know on the DCO side, there were people that said we'd have to go out and hire yet another person, and that we think that we can do this, that the same individual can carry out more than one responsibility in a small operation such as ours.
Thank you. On financial resources, the 3911 B1 and B2 lists the types of financial resources that are acceptable for purposes of enabling a DCO to meet its obligations, notwithstanding a default by its largest clearing member, and to enable a DCO to cover its operating costs for a period of at least 1 year. In addition to the financial resources that are listed, the rule allows a DCO to use any other financial resource deemed acceptable by the Commission. Can you describe how we will make a decision about other financial resources, and will we have to do a Commission order in order to expand that list?
I think I'll answer your second question first. It either could be a Commission order or it could be an amendment to Commission regulation, but I think staff's thinking of Commission action. As far as the type of resource, I guess it's an identification of the resource that people want to use and why they want to use it and why it makes sense for them to use it. And there's two issues. One is a resource that they want to use to meet their Cover 1 obligation, as opposed to a resource that they want to use in order to pay their electricity bills. So I guess the question is, why do you want to use it and what it is you want to use? So I know that I'll bring it up because I know one of you is going to bring it up anyway. The CME has been talking about using projected revenue as a resource, and we said, that the Commission could look at projected revenue. The one issue that I do want to mention is that Core Principle B talks about each DCO shall possess financial resources. So the one thing we need to get over is you don't possess projected revenue. It's something it's something that's projected. So the Commission will have to, if the Commission wants to use projected revenue, I think the Commission will have to, potentially exempt the DCO or pass some sort of exemptive relief from that term possess. So that's the issue.
I do find myself agreeing with this bright line, make it black or white in this area. I mean, I think that this is one particular area where prescriptive rules make it more clear for market participants or for DCOs. And this is an area where for letters of credit, you allow them to be counted as a financial resource, but not for initial margin.
Right.
And if there's a problem with a letter of credit and you have a problem with whether or not the bank is going to fulfill its contractual obligation, why don't you have the same concern with regard to financial resources you do as initial margin? I feel like there needs to be this bright line. And operating revenue, I feel the same way. We say in the preamble that the Commission
Yes, Joe, what page is it in the preamble? Because I keep trying to...
Well, I'm on the September 27th. versions, so it's 49 and 50. In the preamble, it says that we've received inquiries as to whether we would deem projected revenue as an acceptable financial resource.
Page 50.
Right. Okay. And the Commission expects that projected revenue generally would be deemed acceptable for established DCOs that can demonstrate a historical record of revenue, but not for DCO applicants or relatively new DCOs with no such record. So I think it would be helpful. I mean, I'm quite frankly not as concerned about established DCOs who very easily can demonstrate their record. What I'm worried about is how we make a determination of whether operating revenue would be an acceptable use of funds for everybody else. I mean, we have a handful of DCOs that have been registered with this commission for a very long time.
Correct.
That have that record.
Correct.
And I've had a conversation with you about this before. You're not worried about those DCOs.
That's right.
But for everybody else, how do they know? And what does this do for them if they're not going to be able to know?
If we were going to do this, I think the consideration would be, and again, some thoughts for the Commission's consideration is how long the record has to be, 5 years,
Right.
10 years, right? And whether we do any sort of haircut, because let's say that the record is, the quarter by quarter revenues are not smooth. It goes up and down and so on. Then the question is, do we have a haircut as to, because somebody says, I make $100 million every quarter. Well, that's not true because sometimes you make 50,
Right.
So those are some of the considerations.
I trust your judgment in some sort of criteria that we could use to, put that out as some sort of guidance.
Okay.
Can I ask Commissioner Summers, did we, on this one, did we delegate to the head of DCR to make these judgments, or where does that stand? I mean, I think Commissioner Summers just said she trusted your judgment, but I just don't remember what we did, because I remember the preamble language, but frankly I couldn't remember, do we delegate to you or your successors to do this?
No, this is Commission action. It's not delegated. Because the rule says such other resources as the Commission deems acceptable.
But could the Commission not, in this narrow case, just for this provision alone, I don't know if we trust your judgment on everything, Ananda, but
I do, Ananda.
Thank you very much.
I just think it would have been.
I do. Now we're going to give you a delegation of, I think Commissioner Summers might give you a delegation on a lot of things now.
I think it would have been appropriate to put some sort of bright line test in the rule text.
Yeah. No, Ann tells me it is delegated.
So we have oh, good. This wasn't, I was really just, so do we, this paragraph that's on page 50 about financial resources and everything, and you're saying we have delegated that to the head of DCR?
Yes.
Because I think I haven't polled the other commissioners, but I think we have agreement. It'd be terrific if that's just, that is like a DCR judgment, and if you can accept some of these financial resources and operating, it doesn't have to, that doesn't get you all the way there, but that's part way there.
My point is that taking this on a case-by-case basis is not a fair way of doing it. So my point is not that we need to delegate it or not delegate it, but that it needs to be some sort of bright line.
So I see your point. The issue is that two things. One, not all DCOs are created equal.
Right.
So we've got to figure out how far back we look. And then the trouble is if we have a haircut, some of them will say that's too much and some of them will say fine. So that's why sometimes I think a case-by-case is more targeted, because we can look at the particular DCO and look at their revenues.
May I add one additional point? I think that one of the reasons for putting the delegation in was that we're going to get periodic financial reports from DCOs, and just in reviewing them, people might come across a financial resource they haven't seen before, and there has to be some semi-quick judgment. Are we troubled by this one or not? And at some point it would be elevated to the commission, but I think in other cases it might be that the staff might be able to make a judgment.
And I guess that's in the next part of the preamble with regard to the DCO is left up to contacting commission staff prior to submitting the quarterly financial resources report in order to know whether something
That's
counts.
right. That's right.
Well, I think any sort of clarity in this area for the future, I believe, could be helpful.
I can imagine that we'll get something from the CME tomorrow. So.
On letters of credit, back to letters of credit with regard to the differing treatment between whether they're accepted for futures or for swaps. I do think that there's potential for people that are clearing swaps now, using letters of credit as initial margin, for them to have the disincentive to clear in the future if they're end users and are not required to clear, because we're not allowing them to use letters of credit. So in that case, is that something that we would consider on a case-by-case basis?
Yes.
Okay.
Yes.
Thank you.
And
one
again,
last...
I'm sorry, can I add one additional point that the rule prohibits a DCO from accepting it from an FCM. That doesn't prohibit an FCM from accepting it from its end user. Now, they might not want to accept it if they can't pass it through, but they might make a judgment. We will accept a letter of credit from the customer even if we can't pass it through to the DCO.
I think that, correct me if I'm wrong here, but that does not work for NGX, right?
That's right. At least at the moment, NGX does not have an FCM model. They're self-clearing. So
right.
That's right.
So for NGX, you have to post those letters of credit directly to the DCO. And so in that particular case, would we consider the fact that they've done that, it has not been a problem for them?
NGX is a very unusual example, because even though they're a DCO, to my knowledge, most of their business is forwards, cash, and that's the way the business has grown up in Alberta. But in conversations with them, they do have told us that they want to expand into the swaps area, but I think keep their model, the direct clearing model. So, and I've told them that that's something that we can discuss, because we didn't feel comfortable accommodating them, because then it's like going to the bottom. But yeah,
I have one last question, and this is on the contract unit sizes. Rule 3912B5 requires that a DCO select contract unit sizes for clearing purposes that may be smaller than the contract units in which the trades submitted for clearing were executed. And I have questions about how exactly this is going to work in practice, and will it lead to a basis risk for hedge positions?
It shouldn't lead to a basis risk, I don't think, because essentially it would just, if you do a contract that's a $10 million contract and then the DCO says they're going to be $1 million unit sizes, so long as you keep the 10 positions on, you're going to be fully hedged. It might actually give more flexibility to the end user at some point if they decide they want to adjust it somehow. It's easier to adjust by getting rid of $1 million unit than liquidating your $10 million and then re-executing with a $9 million.
If the contract units add equally up to the notional value, but what if they don't?
I don't think they could. I think they'd have to. I think that's the way it would have to work.
Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I spent a lot of my time talking about position limits at first, so I don't want to give short shrift to the important work that you all have done, Anne, John, and Phyllis in Japan, Arigato, for all the work that she's done. But in particular, Ananda, who I think we all respect, and he's a great straight shooter, which I very much appreciate, and one of the stars of the agency. I just have one question, Ananda, and it has to deal with bundling. In the SDR rule, we prohibited that we said that you can't bundle services, and I like it, and I'm curious why we don't have that in this rule, or should we have it in this rule?
Commissioner Chilton, we didn't have that in this rule. We didn't propose it, and so it would be a notice issue for us to impose a requirement now because we didn't propose it. And also at that stage, this issue of bundling, I guess, between an SDR and a DCO, was not brought to the team's attention. It has been brought to the Commission's attention, if I'm not mistaken, a letter that DTCC submitted. But and I think that Commission Rule 49.27, the SDR rule that the Commission promulgated, should take care of it because if I could read it, it's 49.27A2. It says that a registered SDR, consistent with the principles of open access, shall not tie or bundle the offering of mandated regulatory services with other ancillary services that an SDR may provide to market participants. So a DCO that wants to be an SDR has to register as an SDR.
They still have to register as an SDR, therefore they
So they'll be caught, under the SDR rule.
Okay. Yeah, well, that would be anti-competitive if it was allowed. So Thank you very much, and again, thank you for all your work.
Thank you very much.
Thank you to Commissioner Chilton, Commissioner Amaya.
Thank you. My thanks to the team. This is as complicated as it gets, and I appreciate the hard work and patience that you've had with me to explain it to me and walk us through these things. Nonetheless, I still have a bunch of questions. Let me kind of clarify go back to two questions that Commissioner Summers raised. Ananda, you said the statute on the financial resources issue, it's pretty restrictive. It says that we must something about possessing these resources, yet the statute says that for existing, or the rule says that the Commission would deem projected revenue and accepted financial resources to satisfy the requirement of 39.11A2 if they can demonstrate a historical record of revenue, but not the new ones. So how did we get to this point if the statute is so limiting? And I just want to make sure we're clear so that we can continue to use it, because I do believe that these financial resources and these projected revenues are a legitimate resource.
I think this is something that cannot be delegated to me because, and you raise a good issue. This is going to be my preliminary opinion, but it may change depending on consultations with OGC and so on. But it may be that in order to allow us to do this, we may have to issue an exemptive order, precisely because of what the statute says, which is fine. If the commission's, and that will be a commission action.
Okay. But you're standing by the language in the rule, proposed rule.
Right, it's in the preamble.
Yeah.
Right, that the commission could do this.
Now, the second question, Commissioner Summers just asked about 39.12B5, the issue of the contract unit and the basis risk. The statute or the reg says the Commission recognizes that standard products may create basis risk for some hedge positions. I think you had a different take on that.
I think that was intended to address that if there's a standard size and if you do a trade that doesn't fit the standard size, then you're not going to be able to clear it. I mean, you have to clear it in the size that the clearinghouse allows it.
Even if it does create basis risk.
And that would be the choice of the parties.
Okay. Now, obviously the much talked about margin liquidation has the chairman took a strong opinion of it, and frankly, I don't know what the right number is, and I've kind of advocated for a principles-based approach. Now, the rule has 5 factors that the commission's supposed to consider in determining what the appropriate the liquidation risk is. Now, there's been a couple of different things. I'm unclear as to how we use those factors and what balance we found, because everybody else up here has said that we used, because that's what the current practice is, 5 days of current practice for financials, and we should just leave it at that. So are we using this 5-part test, or are we using that's what it is test?
I mean, we're starting with the bright line 5 days, but I guess, for example, if there were a swap that started out subject to the 5-day liquidation time horizon financial swap, and it was subject to mandatory clearing and then subject to mandatory trading and then listed on a CEF and became liquid, I think that would be an instance where the facts would change and that over time the liquidity would increase, and you might well have a DCO come in and say, we would like you to issue an order changing this because it's now traded in a liquid market. It's more like an exchange traded future. So I think that's what the safety valve was designed, and those factors are to sort of think about those kinds of situations.
Well, that makes me think about the last time we did this was on the Dubai, when we went from 2 to 1 day, and that only took 2 years to get that done. So I'm a little concerned that's the process we're setting up here. Now, specifically on the issue of the race to the bottom, the final rulemaking has some tools for the commission to use to make sure that we don't have a race to the bottom. First, and tell me if I'm wrong on any of these. The final rulemaking requires a DCO to determine the adequacy of the initial margin requirement on a daily basis, correct? That's our job, right?
Yes.
Okay. Second, the final rulemaking requires a DCO to conduct back testing of its initial margin requirement on a daily or monthly basis.
Yep.
Third, the final rulemaking requires a DCO to stress test its default resources at least once a month and to report to the Commission the results of such stress tests at least once every fiscal quarter. Fourth, the Commission has the ability to independently back test and stress test DCO margin requirements.
Yes.
And we're going to do all those.
That is the plan.
So where does the race to the bottom come in? How do we, I'm unclear, if we're going to be watching this on a daily, quarterly, monthly basis.
That is the plan, but one thing I cannot control is how many resources we get.
Now, the rule, and I greatly appreciate this, Mr. Chairman, I came to you early on and asked for it, the ags, the energies, and the metals.
It was a wonderful lunch at Maywa.
The Maywa Summit.
Yeah.
I'm going to call it.
No, it was just a good lunch.
You're right, it was a good lunch. At the summit, we determined, no.
I went to the corner wiener shop. I don't know.
I asked, I just posed the question. I said, what's going to happen? You know, we've talked a lot about the interconnection of the markets that led to the financial meltdown. We've got an interconnection of our rules, and we can't think of these individually as much as we'd like to. We debate, obviously, DCO core principles here today, but we have to think about that looming core principle 9 in the DCM reg. Now, if we take all those contracts, the hundreds of contracts that may not meet the 85% test in the proposed rule, turn them into swaps. The original proposal said we were going to have 5-day margin. We have changed that to a minimum of 1 day. It can be higher, and appropriately it should be if the risks are appropriate. Can you walk us through the rationale of going to a minimum of 1 day?
I think the question's on the energy at AGS. It's the rationale on what
why
Commissioner Amalia and I discussed at Maywa.
So you're asking us to explain the rationale for the decision you made?
Yep.
That's what you're asking, right?
No, but it's in the document
that you're advocating for, I assume.
Why 1 day? You gotta have 1 day, right? You gotta have 1 day. If you don't have 1 day, you shouldn't be running a DCO. So the reason why I think the two of you in your summit agreed on 1 day for
the other commissioners have been brought into it since August too.
For the Clearport contract is because we have a history, right, since 2002 of these products being cleared and being subject to a 1 day minimum liquidation horizon. And so far, I've not seen any issues. So.
Yeah, and I'll add, Commissioner Maya, I think on the energy products where we had some commission orders in 2002 for Clearport and then subsequently, not certain it was by order, but by some commission action or staff action for ICE, that's market practice. And that's actually how commenters have commented. On the interest rate market, there is a different set of market practices that have developed primarily around LCH in London, where not only is that market practice, but their comment letter, and I think it was ISDA's comment letter, and then the central bank said the interest rate market, these markets that are at the core center of the bank market, keep at this market practice and not have the alternative that some other clearinghouse might sort of been, trying to compete on, 3 or 3.5 or 4 day or some other margining. I mean, that's, as I remember, the discussions over August and September, because they went a while. But and then I think there really is some very real differences that the interest rate markets and the credit default markets, frankly, they're bigger and they're more systemically relevant. Not that the energy markets aren't big, but in comparison.
I completely agree. I'm just trying to figure out, what if somebody lists a plain vanilla swap interest rate product on a DCM and it gets 1 day, it's identical twin on a swap is 5 day.
I think the issue has to do with liquidity, because if you look at our, the 4D orders that we proposed to the commission, the key issue is what I would call observed liquidity. On a contract market, the commission observes liquidity because it's a contract market, it's fair, it's open and transparent. On other platforms, it's just not clear to me whether we can see the kind of liquidity, and the liquidity is important when you've got to manage if there's a default. So.
And I think also we preserve in this rule, if we finalize it today, the opportunity for that clearinghouse to come to us and petition and say, there's enough liquidity here. This now can move down in this interest rate market. And though it does take time, but that they can do that. Doesn't have to be a full rule. It can just be, bringing something forward to us.
Well, the financial engineers are going to find various ways to play this game, and I just want to make sure that we are not catching ourselves in a kind of a government knows best and then not being able to nimbly respond to these markets to make sure we have the right rules in place. And we are trying to do a very prescriptive rule-based solution here that might not keep up with the pace of change in the market. And I just want to make sure that we're doing good risk metrics using those things and not substituting some arbitrary judgment. I've got a number of other questions I'd like to get to, so I think we've touched on that. The letter of credit issue that Commissioner Summers raised is an interesting thing, and I want to get into that. Now, in a memo to the Commission, we talked about letters of credit. Now, one of the big concerns I have is by eliminating letters of credit, predominantly used by ag and energy users, they're going to be forced to really change their credit requirements and go to their FCM or clearinghouse and get a collateral upgrade. That amounts to a subsidy from Wall Street or from Main Street to Wall Street. And I'm trying to understand, because it's not in the cost-benefit analysis, to the extent that, what is the cost of that?
What do you mean by a subsidy from Wall Street?
Well, they're going to have to upgrade that. There are, as the memo states here, which is not found in our cost-benefit analysis, there's $6.3 billion worth of letters of credit at DCOs today. $6.3 billion. That's a big number. But then you compare, what is it compared to the rest of the margin held by DCOs, and it amounts to just a little over 6%. So systemically, it's a big number, but systemically it doesn't seem like that big a number, yet we've banned that. So people who have relied on it...
We're not banning it for futures, though.
Well, great, but what if today they're a future, tomorrow they're a swap due to our 85% rule, or whatever we select? We're talking about hundreds of contracts that are going to be moved into something else potentially. And even if we went to a lower number, the numbers, you're not radically changing how many contracts will be swept into CEF swap space. So I'm trying to understand. We have some good metrics here. $6.3 billion.
Right.
Now that won't be allowed. And I don't know what the breakdown. It doesn't say in this memo how much is in futures and what. But obviously
all of it is
right.
All of it is futures
until we redesignate some of these as from futures to swaps.
So I don't know what the commission might do.
Well, I'm just trying to understand what the cost of this is going to be when ag and energy commercial hedgers have to come in and get a credit or a margin upgrade for their collateral. What that cost will be as they have to pay to put it in, to go from a flexible letter of credit into a much more acceptable form of. They're going to pay more, right?
Are you assuming that it's going to cost more to get some other kind of collateral?
That's my assumption. Am I wrong?
Why? I don't know. Why? Banks don't do anything for free. It costs money to get a letter of credit, so it's a finance charge. Right?
I get that. It's not in the cost-benefit analysis, though.
You're asking me to do a cost-benefit analysis on something that I don't know. Because right now we're saying you can use letters of credit in the futures industry, which is the current practice. I don't know how many of these products, if any, will be moved to CEFs because of the DCR rule. I don't know. I don't know what the rulemaking is. So I don't know how to do a cost-benefit analysis on a scenario that I don't know what the parameters are.
So if it's only 6.5% of the market, and we're going to preserve it for futures, it's still okay in that. It's not okay in the swaps market. Is it systemically relevant to worth banning if it's some number less than 6%?
It's in the final rulemaking because of comments that we got from members of the commission. Staff didn't think that it should be in the final rulemaking. But, the members of the commission wanted it, so that's why.
The ban?
No.
Okay.
Allowing it, yeah. For futures and not for swaps.
I think what you're saying is staff recommendation was to just not to allow letters of credit for futures or for swaps.
Correct.
Yeah.
Correct.
Right.
Correct.
Can we talk about the recent press stories, ICE Clear Credit? New Edge and MF Global sent a letter, said, ICE Clear Credit lowered their adjusted net capital requirement from whatever it was to $100 million.
Correct.
But then imposed a 5% of customer seg must be held as excess net capital.
Correct.
Now, in the rule, we say $50 million is our adjusted net capital minimum. Nobody can go above that. But it doesn't say anything about a customer seg or default fund or guarantee fund. So I'm trying to figure out
I think we say it's okay to scale the amount of risk that a firm takes.
No, I got that. Let me just finish this here.
Yeah.
So we get a letter from couple of firms saying, still barriers to entry. How are we going to treat that? How would we treat the ICE example?
There's a couple of other provisions that may turn out to be relevant. There's a provision that says a DCO shall not adopt restrictive clearing member standards if less restrictive requirements that achieve the same objective and would not materially increase risk could be adopted. So there's that one. There's also one that says a DCO shall not exclude or limit clearing membership to certain types of market participants unless the DCO can demonstrate that the restriction is necessary to address credit risk or deficiencies in the operational capabilities. So again, those provisions, I mean, we're not judging a particular provision right now, but it's possible that provisions of that sort could be questionable under these, even if they had a $50 million rule and they had some other rule that effectively undermined the $50 million rule.
Because this rule talks about adjusted net capital and not ENC, and so I mean ENC, ICE Clear Credit chose to do that for reasons best known to themselves, but there was no commission regulation at that time. So now that there's hopefully a regulation, as John points out, we would look very poorly upon that practice.
Pardon me?
We would look very poorly upon that practice.
We look poorly on it.
Yeah.
So is there guidance as to any further guidance than what you've read as to how we weight this? Because we just talked about higher standards, banning letters of credit, very restrictive interpretations on 5-day versus alternatives. Now, in this one, we have the opposite. We're trying to find the best opportunity to lower access, and I want more access. I get that, but I'm just trying to understand how we're not. This isn't the seesaw between going out of our way to lower this standard to be a clearing member, at the same time going out of our way to be overly restrictive on some of the other matters. I understand it's a balance, but I'm trying to understand where we are in the teeter-totter here.
So one of the key elements is capital, because as you're aware, Scott, the ANC requirement for FCMs is a function of the risk that they take, right? It's 8% of the risk margin in the customer origin and 8% of the risk margin in the non-customer origin. So that in and of itself, I mean, that's a hard number. So you can track it to the margin, right? You know what the margin requirement is for all of your business. And it's entirely appropriate for a DCO to ask an FCM. Let's say if an FCM is clearing in more than one DCO, it's entirely appropriate for the DCO to ask of it, tell me what your margin requirements are elsewhere. Right? And
can I ask a real quick question?
Yeah.
Does the $50 million, is that per clearinghouse membership, or is that accumulative and you can sign up for as many as you like, to the extent they'll have you?
You can sign up for as many as you'd like, but each DCO is expected to know the kinds of risks its clearing members are taking on. So presumably if somebody was a member of just one DCO and somebody else with the same capital at that same DCO was a member of multiple DCOs, presumably that DCO would have a lower scalable risk for that because they'd be aware they're taking risks at other DCOs.
For example, one of the tools that was used before at NYMEX is capital-based position limits. And in this case, what NYMEX used to do was to ask the clearing member, if it cleared more than one DCO, what its risk requirements were at the other. That's certainly, a fair question for people to ask.
Do you think, as a result of some of these capital restrictions and the way that we view low capitalization, that it would result in a higher margin requirement or a raising of the guarantee fund contributions per firm? Is that the trade-offs that we're going to be making here?
I'm trying to understand the question. Can you tell me what you mean?
So if we have adjusted net capital at the $50 million,
right,
it is reasonable to expect that firms will pay potentially a higher margin, raising the margin requirements or raising guarantee fund contributions.
That could be one of the things. a DCO could say, all right, given your risk at other DCOs, I'm limiting you to these positions. And that's basically what NYMEX used to do. Or they could say, if you want to exceed, you'll have to pay super margin. Or you'll have to, pony up more to the guarantee fund.
And we're going to make the call on all of those as we kind of go forward, correct?
I think we'll let the DCOs make the call first, and we take a look at it and see whether it's reasonable.
Principles, I like that. I'm done.
Thank you, Commissioner Malia, for all of your input on this rule. The Maywa lunch, I think, made it a better rule. I'd hoped we'd get to the place where you were supporting the whole rule, but I think your input has made it a better rule throughout. So, Mr. Staywick, you want to call the roll?
Commissioner O'Malia?
No.
Commissioner O'Malia, no. Commissioner Chilton? Aye. Commissioner Chilton, aye. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this matter, the yeas are 3, the nays are 2.
Thank you, Mr. Staywick. The ayes having it will accept the staff recommendation and send it to the Federal Register. I suspect at some point I need to have unanimous consent on technical corrections, so maybe I'll just do that now for the 3 things that we're doing today. So that's done. I'm going to take for the public a brief break. It might just be 10 minutes, but since we've been here through 2 long things and we're about to take, I know this position limit thing is not going to be 10 minutes. We're just going to take, there's no clock here, but hopefully this is just a 10-minute recess, but it may go 15 minutes. Thank you. We'll be right back.
Thank you. I'm going to call the meeting back to order. It was a good break and productive break. At this time, I would like to welcome Stephen Sherrod. Where's Salman Benai, Rick Schultz, all from the Division of Market Oversight, Andre Karolinko. Oh, you don't have the rest of your staff up there. You don't want to come up, huh? But you've been so involved all along. Don't you want to take a seat up here? From our Chief Economist's Office, Carlene Kim, Neil Kumar, Dan Berkovitz, all from the General Counsel's Office. Yeah, you need to be there. You never know what question you can take. To consider the staff's recommendation concerning the final rule as amended on position limits for futures and swaps. So I think I will allow for the staff presentation.
Good morning, or I should say good afternoon, Mr. Chairman, Commissioners. Today, staff recommends the Commission approve final rules concerning limits on speculative positions in certain physical commodity futures contracts, economically equivalent swaps, and Foreign Board of Trade price-linked contracts available for direct access trading in the United States. The final rules would implement provisions of Section 737 of the Dodd-Frank Wall Street Reform and Consumer Protection Act. The Dodd-Frank Act requires the Commission to establish federal limits on the amount of positions other than bona fide hedging positions that may be held by any person with respect to physical commodity futures, option contracts in agricultural commodities and exempt commodities, such as energies and metals, that are traded on or subject to the rules of a designated contract market, that's a futures exchange, as appropriate. The Dodd-Frank Act also requires the Commission to establish position limits, including aggregate position limits, for swaps that are economically equivalent to futures contracts in exempt in agricultural commodities. Such limits must be imposed simultaneously with limits imposed on futures contracts. The proposed final rules would implement Commission-administered limits on speculative positions in 28 core futures contracts on physical commodities and their economically equivalent futures, options, and swaps. The final rules refer to these contracts collectively as referenced contracts. The core referenced futures contracts were selected because of their high level of open interest and use as reference prices for cash-settled futures and swaps. Staff recommends the Commission establish speculative position limits on reference contracts in two phases. In the first phase, spot month limits would be effective 60 days after the term swap is further defined under the Dodd-Frank Act. In the second phase, position limits for non-spot months, that is on the months, all months combined, and on single months other than spot months, the non-spot month limits would be imposed after the Commission has gathered a year's worth of open interest data that will be needed to calculate the levels of these limits. The initial spot month limits would be based on the levels currently in place at futures exchanges. Subsequently, the spot month limits would be adjusted every 2 years for agricultural contracts and annually for energy and metal contracts. These subsequent limits would be based on the Commission's determination of deliverable supply using estimates developed by the futures exchanges that are verified by the Commission. For a specific commodity, the spot month limit would apply separately to the physically delivered reference contracts and to the cash-settled reference contracts in the same commodity. The levels of the spot month limits in physical delivery contracts would be set equal to 25% of estimated deliverable supply. Cash-settled contracts also generally would be subject to a limit based on 25% of estimated deliverable supply, with the exception of the cash-settled reference contracts in the NYMEX Henry Hub natural gas contracts. Those cash-settled natural gas contracts would be subject to a spot month position limit set at 5 times the level of the limit applicable to the physical delivery natural gas contract, and in addition, an aggregate spot month limit extending across positions in both physical delivery and cash-settled natural gas contracts also set at 5 times the level of the limit applicable to the physical delivery natural gas contract. The final rule would not impose a conditional restriction on these spot month limits. The initial non-spot month limits for the 9 legacy agricultural reference contracts would go into effect, as I mentioned, 60 days after the Commission further defines the term swap. By legacy contracts, I mean those agricultural contracts currently subject to commission-administered limits under Part 150. The new limits on legacy contracts would be equal to the current levels of limits for ICE Futures U.S. contracts and would be based on the levels filed in a petition by the CME Group for other agricultural contracts. That petition essentially computed levels using the methodology in the final rules. The legacy limits would provide for parity with the wheat contracts traded on the Chicago Board of Trade, the Kansas City Board of Trade, and the Minneapolis Grain Exchange. For non-legacy reference contracts, the non-spot month limits would be made effective by commission order after the commission has received 1 year of open interest on physical commodity swaps under the new Part 20, the large trader reporting for physical commodity swaps. Thereafter, for the non-spot month limits on non-legacy contracts, the limits would be adjusted every 2 years based on open interest in the reference contracts. The methodology to set these limits is what we call the 10-2.5% formula, and that is 10% of the first 25,000 contracts of open interest and 2.5% for open interest beyond 25,000 contracts. The open interest used in this 10 and 2.5% formula would be the sum of the futures open interest, the cleared swaps open interest, and the uncleared swaps open interest. These limits would be reset every 2 years. Exemptions for bona fide hedging transactions would be based on the Dodd-Frank Act's new requirements for such transactions. In response to the comments submitted by commercial firms, the final rules in comparison to the proposed rules would broaden the list of exemptions to include, for example, a calendar month exemption for certain anticipated merchandising transactions, as well as exemptions for royalties and service contracts. The final rules also would provide for exemptions for positions that are established in good faith prior to the effective date of the initial limits. Regarding aggregation, the final rules establish aggregation standards generally consistent with the Commission's current aggregation standards in Part 150, including the recognition of the Commission's longstanding independent account controller exemption, clarifying that this exemption is limited to customer positions. The final rules also would establish a position visibility reporting regime in certain energy and metals contracts. The new position visibility reporting regime would provide for standard reporting requirements for very large position holders. This reporting would assist the Commission in conducting surveillance and the analysis of large positions in these markets. The final rules also establish acceptable practices for futures exchanges and swap execution facilities for setting position limits for the 28 reference contracts, as well as position limits or accountability rules for all other listed contracts, including the excluded commodities. I'd like to thank the team that worked on it, particularly the guidance of my division director, Rick Schultz, and in the Division of Market Oversight, particularly Salman Benai. Others that participated from DMO include Ken Danger in consulting and advice received from a variety of staff in product review, Tom Littlefield, Martin Murray, and John Forchio. In surveillance, including David Cass, Dave Amato, Vincent Verasano, Rafael Martinez, Jordan Grimm, and others. In our data analytics group within surveillance, Jim Alton and Gary Martinitis. Of course, the people at the table, particularly Hannah Rope from the Office of Chief Economist. Not at the table, was consulting with us, was Stephen Kane, and of course the Chief Economist, I'm going to mess up your name, Andre Karolinko. Bryce? All right. From the Office of General Counsel, Dan Berkovitz gave us advice. Yeoman's work performed by Neil Kumar and Carlene Kim. We had consulting with Mark Higgins, including while he still worked in enforcement. And of course, I'd like to thank the chairman for his guidance and his direction, and the commissioners for their direction, and the advice received from all the commissioner staffs. We'd be happy to answer any questions.
Thank you, Steve. Thank you for thanking us. I didn't know that you liked it every day. The chair will now entertain a motion to accept the staff recommendation and consideration of this final rule as amended.
So moved.
Second.
I am going to support this final rule to establish position limits for physical commodity derivatives, and I have a longer statement that will go on our website and may even already be there. But I do want to say a few things and ask a few
questions, if I might. The CFTC does not set or regulate prices. In fact, that seems to be something each of us have said somehow in our opening statements. Might even be worthwhile to put in the preamble so that it's a commission statement. But rather, the commission is charged with a significant responsibility to ensure that markets are fair and open, efficient, functioning both in the futures marketplace and now with these new responsibilities in the swaps marketplace as well. And it's our duty to protect both the market participants and the American public from fraud and manipulation and other abuses. So where do position limits fit in? We don't set or regulate prices, but we have to ensure for the integrity of markets and that they're fair and they're without manipulation and other abuses. Well, they've fit in since the 1930s, in fact, as a tool to curb or prevent excessive speculation that may burden interstate commerce. Those are not my words. Those are Congress's words. And they seem to have been in one version or another all the way through. And when the CFTC has addressed position limits in the past, the agency sought to ensure that the markets were made up of a broad group of market participants, with no one speculator having an outside position. See, hedgers and speculators meet in a marketplace. If you just limit it to a marketplace to only hedgers, there might not be enough liquidity in the marketplace. And in fact, if you take the classic example in corn and wheat, you might have a lot of farmers and merchants who want to, naturally they're long, they have the corn or wheat, and they need to find to lock in their price somebody on the other side. And that's where the speculators are providing risk reduction, in essence, to the marketplace. But at the core of what Congress has asked us to do and what we've done in the past is this obligation of promoting market integrity, which the agency has historically interpreted to include ensuring the markets do not become too concentrated. So you might say, well, what is too concentrated? We've actually had some formulas in place for some time, and it leads to my first question, but there's two forms of limits, one in the spot month and one for all months combined, and we're considering finalizing a rule today that says in the spot month that nobody will have more than 25% of the deliverable supply. That's the supply that's in around where the product is delivered. So my question, Mr. Sherrod, or anybody else who's a good historian, Mr. Berkovich, you always have the history, how long have we used this 25% of deliverable supply? Is it in a rule? Is it in guidance? Where does it come from in our past? Now, Rick Schultz, who's been with the agency since we actually came from, 1975 you joined the agency.
Yes, that's right. I think the rule goes back to not as a rule, but more as a kind of a rule of thumb. Is something that the CFTC's predecessor, the Commodity Exchange Authority, had basically used as kind of a way to assess what should be a spot month limit in considering limits for the agricultural products at that time. And it's ultimately was incorporated into our guidance, but I think it has a very long history, probably 30 or 40 years. It's kind of a rule of thumb that seems to have made sense. It's something we've worked with the exchanges over the years in developing or reviewing their the speculative limits that they would certify or send to us for approval.
And Rick, I take it though it has many reasons. At the center of it is to ensure against corners and squeezes and manipulation around delivering a physical product in those last few days.
That's correct.
And then the same question on limits on the rest of the curve, what's called all months combined, this 10 and 2.5%. Where does that formula emanate, or when did we put it in rules in the past?
That also, I believe, is essentially, as Rick said with respect to the spot month limits, reflective of longstanding agency practice going back, I believe, even to the 1940s, that essentially the limits were in that percentage range as far back as then. It was in the early 1990s that it became part of regulation, the 10-2.5 formula.
And did we do that by notice and comment at the time?
Yes.
So it's been in place in our rules, both of these formulas, for some time.
That's correct.
It was the 2.5% so we can respect the man that was behind it, Blake Immel. Was that the gentleman here?
Blake Immel was the Deputy Director in the Division of Economic Analysis. That's correct.
So, as you can see, these have been around for some time. In 1981, in fact, the Commission said that in addressing this, the capacity of any contract market to absorb the establishment and liquidation of large speculative positions in an orderly manner is related to the relative size of such positions, i.e. the capacity of the market is not unlimited. And that was about 30 years ago when we addressed these things. Well, then Dodd-Frank came along, and Congress mandated that the CFTC set up aggregate position limits for certain physical commodity derivatives. The Dodd-Frank Act broadened the CFTC's position as well to have authority to set aggregate positions for not only futures but also economically equivalent swaps and also some contracts that might be on foreign exchanges or what we now call foreign boards of trade that are linked contracts. Congress also narrowed the exemptions traditionally available to position limits by modifying the definition of bona fide hedge transactions, and thus much of the discussion and I'm sure further questions. But it was particularly focused on swap dealers. Is that right? I just want to pause on that question.
That's correct.
So, Steve, I guess I do have a question for you. Is when you think of commercial hedgers in the marketplace, in essence, the bottom line is, will they be able to continue to do that which they've been able to do in the past and hedge in the futures and swaps markets and, in essence, be bona fide hedgers and exempt from some of this?
Absolutely. To the extent commercial firms are engaging in risk-reducing transactions of their inventory positions, for example, or fixed-price purchase or sales contracts, absolutely.
And how about anticipatory hedges? I know that's been something that's been in the comment file.
The Commission's current regulations address anticipatory hedging in 1.48, and we've pulled all of those over into the new rules that are before you, and we've expanded that somewhat.
And then just some of the stuff that we were doing on the dais here, or dais, so forth, have you also given in this amended text in an avenue? Would you want to describe that, which we were talking about in the last hour?
Absolutely. Besides providing a list of examples of bona fide hedging transactions in an appendix to the proposed final rules, the staff has worked at your direction and the Commissioner's directions to clarify in the rule and in the preamble that persons that would seek interpretation to try to understand their transaction, whether it's bona fide or not, can come to the staff or the Commission and receive that interpretation. And further, the Dodd-Frank Act provides that those seeking relief, the Commission has the ability to issue an order under new Section 4AA7.
So, again, your answer is you think that we do cover all of the examples that we, the common practices in the industry today. Is that right?
That's right.
But in addition to that, if somebody thinks, well, maybe we're not covered, they can come and knock on the door, and we can address that at staff level or Commission level. Is that right?
That's correct.
Today's final rule implements those important provisions. It fulfills, I think, the congressional mandate that we set aggregate position limits and, for the first time, apply them to both futures and the economically equivalent swaps and foreign board of trade contracts. As Steve went through, of course, it's on 28 reference contracts in energies, metals, and in the agricultural areas. I won't go through the details, but I will say that I think that we've been significantly benefited by public comment. 15,100 comments, is that, I think?
And 600 and something more this past week.
Yeah, and if I just judge by the phone calls that each of us commissioners have gotten, maybe it's now over 16,000 comments. We've also benefited from an earlier proposal in January of 2010 that we got over 8,000 comments. We had 3 public meetings in the summer of 2009 on possibly bringing position limits back to the energy space. We benefited one in early 2010, possibly to bring them to the metals markets. I think it's been an enormous engagement with the public on this. But there'll be, no doubt some further engagement and implementation of this if we finalize this today. And I think that it's important for the public to understand that the staff and the commission stands ready if we finalize this rule to address your questions, interpretations, guidance, because at the core, these markets must work for bona fide hedgers, have enough liquidity that is provided at times from the speculators, but to fulfill congressional mandate. I think that that's probably it for me, but I might have a question or two as other commissioners weigh in. But I'm going to turn it over to Commissioner Dunn.
Thank you, Mr. Chairman, and I want to thank the staff, both the staff of the commission that has worked so hard on this, but collectively the staff of the commissioners that have worked together to pound out issues and right down to the wire, even moments before we reconvene, of coming up with amendments that make this as workable as possible. And Mr. Chairman, is well known that I was very skeptical of this provision, and my negotiations with you personally have been exceptional and providing opportunity to have input and to address the needs I have. I do look forward for you coming out to wash the windows and clean the gutters before snow flies.
Anywhere you want me, Commissioner Dunn.
But you did agree to have a colloquy with me that will provide me with some of the assurances that will make me comfortable with the final vote on this. And if you would, please, Mr. Chairman. Once this final rule is implemented and goes into effect for the spot month and for other months, will we be actively monitoring the trading to determine if the limits have any beneficial or detrimental impact on the trading that takes place in the futures or swaps markets?
Yes, we will. In fact, Congress has mandated that we conduct a study regarding the impacts of position limits on excessive speculation and on the movement of transactions from U.S. exchanges to foreign exchanges. We're supposed to do this 12 months after the limits are effective. So the answer is yes, and in addition, we have a study to do.
If we discover that the position limit rule is a cause of a major market disruption or has an unintended consequence we realize must be addressed, are you committed to working with the commissioners, the exchanges, and market participants to correct the problem as expeditiously as possible?
Absolutely, yes.
If the market user comes to us because these rules have had an adverse impact on a legitimate business or hedging practice, how will you advise them to proceed?
The market user should come and ask staff, and in fact I think this additional amendment helps in that regard, Commissioner Dunn, but even beyond the additional amendment to 151.5, staff can clarify whether there is an issue for providing guidance to that market participant or working with the commission or general counsel to provide such interpretation. There are various means to do that. If those routes do not address the concern, of course, the market participant can come straight to the commission as well through various means of petition and otherwise for changes. But I do think that we have exemptive provisions, as Steve Sherrod mentioned, under 4A7?
4AA7.
4AA7. But also I think this additional provision that we just worked out is helpful in this regard.
This may be redundant at this point, but as I said in my opening, I believe the agency is in the business of protecting and promoting the price discovery process and not in the business of setting price. Do you agree with that statement?
Wholeheartedly.
How will this rule impact disruptive trading practices and market manipulation and the resources the Commission expends to combat them?
I think this rule is another tool that we have to protect price discovery and promote fair and open and competitive markets. It helps protect against parties, I'm going to use the glasses here, but parties having excessive market power and therefore protects against corners and squeezes and other manipulative schemes. The position reporting included in the position visibility portion of the rule will provide the Commission with valuable information regarding large market participants in the markets. This information will allow us to be more efficient in our surveillance and enforcement activities. It will also allow us to leverage off of additional staff. I think it was estimated, Rick Schultz has given us some estimates, that there will be a need for about a dozen more staff, but I think this rule will allow us to be more efficient elsewhere, whether it be in enforcement and surveillance.
Mr. Chairman, I've saved those arrows for you and not the staff because they've been working all along with us, but I do have one particular question of the staff. And it's a question that was posed to you on June 15th by Senator Roberts that you answered orally, but I do want to get this on the record from the staff as they perceive it. And the question the senator had was that a Summer County, Kansas elevator expected in the near future to enter into forward contracts with area wheat farmers at a fixed price with delivery at a later date. To hedge this risk, the elevator goes short at Kansas City Board of Trade wheat futures. Under the CFTC's proposed rule, and that's as amended now, no, that wasn't in his question. Let me get back to just quotes on his question. This would seem to make the elevator futures transaction a speculative one and therefore not eligible for the commercial hedge exemption from any position limits, since at the time the elevator's futures position was taken, there in fact was not an underlying physical contract, excuse me, let's get my terms correct. Steve, in your opinion, with the amendments that were made this morning here in this proposed rule, what is your answer to this question?
I think I was listening carefully, and I think the answer is yes. The commercial participants trying to reduce risk in the operation of their commercial enterprise, and that's the essence of a bona fide hedging transaction.
You had me at yes. I want to thank you, and I want to make sure that those common practices that have been out there in the agricultural sector are not at any way at risk, and if people feel they are, that they will get a prompt response from the staff.
I too just want to make sure that last part, that if there are common practices that are risk reduction and market participants have questions, they certainly should knock on the door to get the comfort and the certainty that they think appropriate. We think we've addressed the common practices in this list of enumerated pieces, which is in section 151.5. But again, if there's something that we haven't addressed, to let us know.
Thank you, Mr. Chairman.
Commissioner Summers.
Thank you, Mr. Chairman. I'm going to start with some questions on deliverable supply and want to clarify that the spot month limits will change annually for agricultural contracts, but every other year for energy and metals. Is that correct?
Yes.
Okay. So right now, how long has it been for some of the major agricultural contracts? How long has it been since we've changed a spot month limit?
So for the 9 legacy contracts, the Commission does that by rulemaking, and I think the last rulemaking's been quite a few years. Rick, do you want to?
It's been a few years. I don't remember exactly.
In I believe the last time we put out a notice and we did not go final. 2005?
So it's been 6 years since we've updated limits in the 9 legacy contracts. Going forward, those spot month limits will change every year based on deliverable supply from the previous year. Is that correct?
The exchanges will provide us with their estimate of deliverable supply, and I would expect it would cover at least the prior year, and it's likely to cover many years. And so if the level of deliverable supply doesn't change, I would not expect the spot month limit to change.
And how likely is it that from crop year to crop year there isn't a change in deliverable supply?
It is true that from crop year to crop year, absolutely, the harvests vary. The amount of supply that's available at the different delivery points, because they're local focused delivery points in the normal cash marketing channel, my view is that they probably shouldn't change much. Rick, you want to provide?
And I think typically what we would do is look at something beyond a 1 year, kind of try to look at a 5-year average of production and supplies at the delivery points. And I think generally, when you look at any specific commodity, I mean, they're specifying delivery at a specific point, and the cash market generally doesn't change that fast or that much. So I would guess that typically, even though we'll get updated estimates of the deliverable supplies, that you're not going to see a lot of changes from year to year, that it'll be more evolutionary as the situation changes at a particular delivery point.
So I guess that brings me to another concern of mine, and that's the methodology that we're going to use to allow the exchanges to calculate what the deliverable supply is. The preamble states that there were comments urging the Commission to include supply committed to long-term supply contracts in its definition of deliverable supply to avoid artificially reduced spot month position limits. Instead of doing that, we have revised 151.4 D2(4) to clarify, for purposes of estimating deliverable supply, the DCMs may use any guidance issued by the Commission set forth in the acceptable practices for Core Principle 3. So we're not dealing with it here, we're going to deal with it in another rule, and I guess just hope for the best.
Well, I think there's been a little bit of confusion, and maybe it was in the way we characterized this in the discussion about long-term contracts. But the real focus is on what might be committed for other uses at the delivery point. And typically, if something's under a long-term contract, it may be committed and not available. But in some circumstances, depending on the commodity, the commodity might be under some long-term contract but be available for delivery, and that is something we want to clarify when we do the acceptable practices in the DCM rulemaking. I've already had some discussions with some of the exchanges about that, so it's not this rigid. If it's a long-term contract, that it's automatically out. So we want to clarify that it really goes to, are the supplies committed to some other use and really not available.
So just in case, in some certain commodities, there may be 100% of the deliverable supply that's under some long-term agreement, we intend to be flexible with whether or not we use those.
Yeah, we don't want to get into whether it's under a long-term contract or some other contract. It really goes to the essence of that and whether those supplies really are available for if you're a short and you want to make delivery.
Okay.
So it's entirely possible for some commodities that most of the production or the supplies at a particular point might be under a long-term contract, but in fact be made available to the market, and it's specific to each commodity. But we would look at that.
I think it's unfortunate that we didn't make that more clear here, that we didn't clarify, that we didn't mean to suggest that in calculating deliverable supply we were making some wholesale change from current practice and from the way that exchanges currently make those calculations, but we chose not to do that. The other question I have with regard to deliverable supply is the answer to the previous question on we haven't updated those numbers since 2005, and do we intend to allow exchanges to update those numbers between now and the time that this rule goes into effect, because it may make a difference to some commodities as to whether those numbers are allowed to be updated.
So the draft rules that are before you do not make that provision. The exchanges were generally on notice since January of this year of the intended approach. My concern, for example, would be that the spot month limits will go into effect 60 days following the definition of swap going final, and that that date is still uncertain. When we do, in Division of Market Oversight, receive the exchange's estimates of deliverable supply, we go through a process of verifying those, including trade interviews, and that can take some time. So my concern is that we would not be delaying the implementation of spot month limits because of perhaps every single spot month limit being filed with new deliverable supply estimates. So again, I think the exchanges were on notice, and if they had intended to change them, they certainly would have submitted them.
Well, I think unfortunately there was no way to know in January that we were not going to allow them to update the numbers. So if I can just go through a real quick calculation, if a swap is defined in spring of 2012 and spot month limits will be updated as of January 1st of the second calendar year after the spring of 2012, it puts us at January of 2014 to even redo an estimate of deliverable supply. So we haven't updated the numbers since 2005, and we may not update them again until 2014. I think that's a problem. I'm going to move on to bona fide hedging, and I understand that we've made an amendment to allow people to come to the exchange or to the commission and ask for some sort of exemptive relief, but I just want to clarify a couple of things. The statute did narrow the definition of bona fide hedging to exclude risk management exemptions, but it didn't exclude anticipatory hedges or disallow non-enumerated hedges. Is that correct?
That's correct.
And so has there been a problem in the past with these type of hedge exemptions to where commercial end users, producers, processors, all the list that I went through in my opening statement, they have qualified for and used these type of hedging strategies? Have we seen a huge problem with this?
In my experience in surveillance over the past few years, and in a current accounting of exemptions that were used under existing 1.47 for non-enumerated, for example, 21 are for swap dealers for risk management. One is for a government entity that's covered in the bona fide hedging exemption, and there are no others outstanding.
Well, I guess it's possible that those type of hedging strategies have been granted by the exchange, right? So the exchange has allowed an entity to use those type of hedging strategies to receive a hedge exemption, so it wouldn't necessarily be something that we've done.
That's correct. Outside the 9 legacy contracts, the exchanges have been implementing their own position limits.
So I'm just saying, in general, if we've seen a problem with the exchange granting an exemption for some of these hedging strategies that we are now disallowing, is there a reason for disallowing them?
I've got to say I'm not familiar with the disallowed transactions. We looked carefully at the comment letters and tried to provide for everything that we reasonably could foresee in the enumerated list. And as we've mentioned, we provide 2 different avenues, either an interpretive avenue for staff or an exemptive order by the Commission to allow for bona fide hedges that aren't in the enumerated list.
We can agree to disagree here, I guess. I feel like the list has been narrowed, and it's now there's nothing beyond that list. You know, we have a list of what qualifies as an enumerated hedge, and that is what the definition is now. I have one more question and this is with regard to something that I have mentioned a number of different times, and we received a comment letter on this issue from Senator Lincoln last year advocating that we treat unleveraged index funds differently for position limit purposes. We're not doing that, but the preamble says that additional analysis is needed. So I wanted to ask you what additional analysis is required before we would look to impose a separate position limit regime or establish an exemption for a group or class of traders.
I'll turn to our chief economist and see what his thoughts are on an exemptive regime. My very basic thoughts is that we should have a reasoned basis to provide an exemption for a particular class or group of traders or a particular type of trader in the marketplace. And what we've done in the proposal before you is pull over the existing bona fide hedging exemptions, replicate those, and add to those based upon the comment process where they fit the traditional view of what a bona fide hedger is. And in terms of whether someone's leveraged or not, the question of margin hasn't been a relevant factor in determining whether someone's a bona fide hedger. Andre, do you have?
I think on the additional analysis, there is on a class or group of traders or on the impact of non-leveraged commodity index traders on this. We are, as you know, at the Office of the Chief Economist, are continuing to monitor what kind of studies are being done, and there are studies being done both internally and externally on the impact of commodity index traders, commodity index funds, and so far there is no, as Commissioner Dunn stated, you know, in his opening statement, there is a sort of legitimate debate going on this, and would like to be able to validate quantitatively first the impact and the role of commodity index traders. Would also like to perhaps go and look more closely at the categories, at the categorization of index traders. You know, as you know, we had a supplemental COT report out there for a period of time. There is, as I said, we have a supplemental COT report there for a period of time since 2006. So the overall role of these are relatively new entrants into this market that have become relatively important. So their overall role with regard to other participants and how they interact with other participants has to be examined, and whether or not the benefits, or whether or not what they were supposed to provide, which was the long side to short, potentially short commercial hedgers, is something that they really satisfy, and at what cost.
I appreciate that answer, and I guess I look forward to us conducting the type of analysis that would give us the ability to make a decision as to whether or not, you know, a different class or group of traders should be treated differently, because Congress specifically gave us that authority, and I'd like to see us be able to analyze whether that's appropriate. I claimed I only had one more question, but I just thought of my last question, which I also talked about in my opening. If any of you at the table actually believe that position limits will control the price of a commodity or stabilize market volatility.
I think position limits are not to set prices. I think they're to address the situation where there is an extraordinarily large trader, and that's the proposal that we've presented to you.
Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Mr. Kurlenko, do you have any evidence that speculators, whether index funds, have any impact on price? Have you looked at that?
Yes, as I said just now in my response to Commissioner Summers, there are a number of there is a very healthy research effort underway looking at exactly that issue, and we are the position limits team when we were working on this reviewed 52 studies. These 52 studies were specifically submitted to during the notice and comment period. And some of those studies do look into this issue.
But you and your shop, I'm sorry to interrupt, and feel free to finish if you want, but I was asking about the economist at the CFTC. Have you done anything? And if not, go ahead and finish your answer with regard to other studies. But I was curious about in-house here.
Whether or not we're able to quantitatively validate the exact nature of the impact of commodity index traders, we're looking at it. We're not yet at the point where I would be comfortable saying that we've reached a firm quantitative conclusion.
Thank you. And thank you all for your work on this. I know it's been time-consuming and a pain at times, and I've been part of that pain. But thank you for your perseverance. I have several questions. On the conditional limits, Mr. Sherrod first. So what the rule says is that we're going to go 1 to 5 on natural gas, and then we're going to go 1 to 1 on everything else. We do have some experience in the 1 to 5 on natural gas because it's a SPITIC contract, and so we've got some evidence there, something to sort of hang our hat on. And then in 12 months after we've collected the data, we will go final on the swaps limits, and at that time, when we're doing that, we have the authority to reassess all of the limits if the Commission so desired. Is that correct?
So I think the answer is yes, and Commissioner Dunn said that was a good answer, so I should stop there.
I'll accept that too. Okay, now, Mr. Berkovich, 737 says, and help me if my memory does not serve me, that there are 4 criteria that we look at with regard to how we are to establish position limits. The first one deals with guarding against excessive speculation. The second one asks us to ensure and deter manipulation, squeezes, and corners, I believe. Is that correct?
That's correct.
Okay. The third is that we ensure that there is appropriate liquidity in the market so that hedgers have the ability to continue to hedge. And the fourth criteria is to ensure that there's appropriate price discovery going on. Those are the 4 criteria that we're supposed to look at in setting these limits, correct?
That's correct.
The 1 to 5, the 1 to 1, the conditional limits, does this rule satisfy the legal requirements under 737 as we've just described?
The rule sets forth the Commission's determination that these criteria are satisfied. In that respect, yes, Commissioner.
Thank you. I want to, and I'm sorry I'm going around here because my colleagues have all asked good questions, and so it's not really a logical order. When Commissioner Summers, who I always follow, is going, I kept saying, well, then I'll follow on to that. So I apologize for being a little bit discombobulated here. I wanted to go back on the anticipatory hedging just a little bit, and thank you for the colloquy between Commissioner Dunn and the chairman. The last thing that Commissioner Summers asked you, Mr. Sherrod, was, what about all these things we don't know? And your answer is essentially, well, I don't know. I don't know about them. But I'm concerned also that, as Commissioner Dunn often says, we don't know what we don't know. And so there may be something out there that is a practice that we aren't familiar with. I'm going to ask about those in a couple of seconds here. But in general, the list that we have in the rule, do you view that as an exclusive list,
No, not an exclusive list. It's the available bona fide hedging exemptions that we've enumerated.
Yes. Okay. So it's not exclusive. There may be other things that we don't know about yet, and people come explain them to us. So let's get into those, shall we? So say you have a history of having a contract every year. Some country you always sell them wheat or beans or whatever it is. Every year they come to you. This is before the crop's in the ground. And every year you sign a contract. But you don't have any skin in the game yet. You're a large commercial aggie. You don't have any skin in the game yet, but you know it's going to happen. It happens every year. That's something that we don't necessarily address precisely in the rule. How would we deal with that? Because it's my understanding that that is a practice. It may be one of these things we don't know enough about, but it is a practice that occurs.
Right. So when a person would be seeking the staff's views about whether something would be bona fide,
right,
we would look to the particular facts and circumstances of the situation. So if they're reducing risk, if it's inventory, if it's fixed price contracts, we also provide a number of anticipatory requirements and input provisions, then it's bona fide. If it's
but nothing's in the ground yet. They're just anticipating what has happened maybe for a couple of years. Would that evidence, for example, of previous contracts over the last few years, would that potentially be something that could be on your list of things that would be anticipatory with regard to the bona fide hedging exemption?
I think what I was trying to refer to, because I wasn't quite sure of the facts of your hypothetical, is that, for example, someone that's an anticipatory producer, that's an enumerated bona fide hedging transaction. So they don't have to have already produced it. Likewise, they don't have to have already produced their output if it's an input into their process or manufacturing. Those are well-recognized anticipatory hedging transactions.
What are we doing with regard to large product offering, that issue?
I would need to know more. I'm not sure what you mean.
Have we ensured that we've taken care of this issue about large product offerings? Do you need more than that?
I need more than that.
Okay. How have we ensured that the commercials can use the anticipatory hedge exemption for the pass-through? I mean, and Commissioner Duns, Commissioner Summers talked about this. You got a grain silo, and you fill it up, and maybe you have 85% in the elevator there. So your capacity, you might say to somebody who doesn't know anything about ag, well, it's 15%. You got the remaining. But this elevator could be filled a dozen times or 5 times throughout the harvest. So how do we address that?
Okay, now I got it. So in the list of enumerated bona fide hedging transactions, we provided a new one in response to comments. And it allows someone that has either owned or leased storage capacity, either currently unfilled or reasonably anticipated to be unfilled, and perhaps they will fill it and unfill it a number of times.
Correct.
Those would be available as a bona fide hedging transaction in the form of a calendar spread to reduce their risk of having that unfilled capacity.
Okay.
Thank you for those.
Can I, Commissioner Chilton, ask a question in there? You asked the word about pass-through.
Yeah.
And so I just want to make sure the pass-through, Congress has a pass-through exemption as well. Is that available to agricultural cooperatives that are, presumably are not going to be swap dealers and so forth? We have to finalize that rule, but a non-swap dealer, do they get the benefit of this pass-through as well?
And so I was reading Commissioner Chilton as turnover in a storage facility.
Right. I'm asking another piece of his question just to make sure that we can have that addressed as well.
So with respect to a party to a swap that's opposite a bona fide hedger, that counterparty gets to treat both that pass-through swap and the risk-reducing transaction, which will net them down to no risk, as bona fide as long as they're reducing that risk down.
So an agricultural cooperative or a grain elevator operator that might not be a cooperative, if they have a swap with a member of the co-op on one side and then they go to, some, risk-reducing swap on the other side, they get the same pass-through or look-through that, Wall Street gets.
Any counterparty opposite a bona fide gets that treatment.
Okay. Anybody gets
whether it's a co-op or other.
Well, I happen to be interested in co-ops right now, but yeah, all right.
Well, let me just, you went down this little cul-de-sac, and so I'll stay down there with you just for a moment. So how will agricultural co-ops be treated under this rule? This is essentially what the chairman was saying, but if they are laying off risk of their members, will those risks in essence pass through to the members and not be attributed to the co-op for the purpose of compliance with position limits?
So to the extent, just like any other firm, a co-op has inventory or fixed price contracts, those are bona fide hedges. To the extent they enter into a swap contract with a farmer and they don't actually have the physical commodity, but it's a cash settled swap, then they would be a bona fide for the look-through provision that they could, I know it's kind of complicated, but then they could lay it off. Yep. And the combination is the co-op hasn't taken on risk between the transactions, and that's the intent.
That's good. Thank you. Appreciate you explaining. Now, you sort of addressed this in a couple of ways, but I want to ask a question specifically about capacity. How are we defining capacity? I assume it's based upon annual volume of the commodity that moves through the merchant, through a merchant, and not the unfilled capacity like we talked about, a grain bin or whatever. But is it a volume? How will we do that? Is it 5 times what could be in the bin, or is it 10 times? Or
so the rule text doesn't define the term capacity specifically. We've always looked to what is reasonable when we use plain English language. So in terms of unfilled capacity, whether it's current or anticipated, someone can reasonably anticipate knowing how many times they can turn over their capacity. So we would look to whether that's a reasonable turnover.
And is it based upon like historical data, or based upon what farm equipment they have that year, and then they buy another combine the next year, or how do you?
This again is this particular exemption is for storage capacity, so it would be based upon what's a reasonable load-out capacity of the facility, and that could change as they make improvements.
Okay. By the way, when does the new definition of bona fide hedging go into effect under the rule?
So the new bona fide hedging definition would take effect in the spot month in particular, 60 days after the term swap is further defined.
Okay. Give me just a moment here, because my colleagues have asked so many of these, but I want to make sure that I get to all of those. Independent account controller. Have we adequately addressed the issue with regard to energy and agriculture entities that are part of commercial and part commercial and part financial? And how do you deal with these guys that they've got part of their shop is doing financial speculation, and part of it is actually hedging their business risk, and you've got them together, they have lunch in the same lunchroom, they're not separate management structures or anything. How do you divide that up? Or do you divide it up?
We don't divide that up. In this final rule, it follows the existing practice of treating such a conglomerate of different organizations that are commonly owned and controlled as a single person. We aggregate them for purposes of the position limits. Now, that single person may have bona fide hedging activities, and they would qualify for the bona fide hedging exemption to the extent they're reducing risks in their commercial.
But they would have to prove that, sort of my thing about the boss, and you got to prove it all night, that they'd have to be coming in, you don't have to accept my prove it all night thing, but they would be coming in and explaining to us their strategy for and why they need this business risk. And so if they couldn't explain the speculative part, they wouldn't be able to get the exemption for that.
Right. We wouldn't ask them to explain the speculative part,
right,
but to the extent they're filing a notice.
But the speculative part would fit under the limit.
Under the limit. And to the extent they wish to exceed the limit, they would file a notice to claim the legitimate business purposes for a bona fide hedge.
And just to be clear to folks who might be listening, when we look at these, provided we have the resources, as Ananda was talking about earlier on his rule, to look at these things, the bona fide hedging strategy, and they're going to give us every month, they're going to prove to us that they needed these hedge exemptions. If we determine, assuming we have the resources, if we determine that they are abrogating that strategy and that they are engaged in speculative activity outside of the constructs of the bona fide hedge exemption, we can shut them down for that purpose. Is that correct?
Well, in the Division of Market Oversight, we would refer them to the Division of Enforcement.
The CFTC may shut them down if they are inappropriately using such a hedge exemption.
And again, I think we would.
Let me just say, we will shut them down if they're inappropriately using a hedge exemption. Okay, adjustment to limits. Now, the rule says that we will examine, readjust, recalibrate, the word I use, every 2 years. But also we're going to be considering the spot month limits next year, and that may have some impact on other limits. That doesn't mean that we will change the 10 and 2.5, although as I mentioned in my opening statement, there's some I think should be a little bit tighter, but particularly metals. But that is also a time at which the Commission may avail itself the opportunity to readjust or recalibrate these limits. In fact, is it not correct that the Commission may at any time, tomorrow, well, we'd have to wait till they're in effect, 61 days from today, we may reassess. If there is some big, huge change in open interest and we determined, Chairman wanted to bring it up and he had 2 other votes, we could determine that the levels, the 10 and 2.5, were inappropriate, we could readjust them. So the rule requires that we do it every 24 months. But there's nothing in the rule that prohibits the Commission under plenary authority from reassessing this matter at any time. Is that correct?
That's correct. That, as you noted, that is the Commission's plenary authority, and there's nothing in the rule which would restrict that authority.
Okay. Again, pardon me for just a moment, so I'm not redundant. You have survived. Thank you. Appreciate your time.
Thank you, Commissioner Chilton. Commissioner Amalia.
I think it's tough going after Commissioner Summers. What questions are left? Let me dig around in my bag of tricks.
Yeah, they're just such a...
There's a few here.
We all work so well together. We left you a few.
Before I start with my script, back to this anticipated merchandising. What are the rules today for anticipated merchandising? What do anticipated merchandisers have to prove today?
So the current provisions in Commission Regulation 1.3Z point in the 1.3Z3, the third provision, have a specific example that says, for example, someone that is merchandising that has a contractual agreement, they're acting as an agent for a party that's actually bona fide, then if that agent is laying off the risk, that's the extent of what we currently have recognized.
So in all of this, we have several more and several different criteria other than that, and we have not defined merchandising in the reg, correct?
That's correct. It's,
right.
It's a term in the statute.
Okay. Oh, in the okay. So we have this, the new requirement is that they have to demonstrate they have unfilled capacity, owned or leased, and the anticipated merchandising activity may not exceed 1 year. I assume that's the amount of storage that they have to prove. They can only they're only limited to.
That's the time horizon.
The time for 1 year. That
right.
For what they have to prove, the unfilled storage capacity is for that 1 year period, right? Okay.
That's correct.
They have offsetting sales and purchases, and then we have another C, which is no such position is maintained in any physical delivery reference contract during the last 5 days of trading of the core reference futures contract in an agriculture or metal commodity during the spot month for other physical delivery commodities. What does that mean?
So essentially, if a merchandiser has unfilled storage capacity, they would not appear to have a need to make or take delivery on the nearby contract. That is the spot contract that's nearing delivery.
Okay. So merchandisers ought to be on notice. We have provided for them. It's a different set of rules and it's complicated, but if they can prove these factors, then they're eligible to come in and get their merchandising exemption.
That's correct.
Now, in this new exemptive authority that we've amended here, are they also entitled to use that if they have something slightly outside of this prescriptive three-part test?
So the exemptive authority is the Commission's authority under 4AA7 to issue an order. And so any person's free to petition the Commission for relief.
Including these guys? Outside of the three-part test?
Yes.
Thank you.
Commissioner Amalia, can I just ask, because I think it helps your question, but I just want to make it sure. The thing that's currently in 1.3, Z3, was that it? The agency piece? Did we pick that up and move? Is that still available, this agency piece?
I think that's in there, yes. We tried to pick up everything that was in there and move it over.
I just want to make sure we didn't lose that somehow. If you might tell us which section, if somebody else, as you're answering, I don't want to take you from Commissioner Malleus, but maybe, Neil, you can find the section.
What is the Commission's working definition of excessive speculation, and what criteria do we rely on to determine what speculation becomes excessive?
So we don't particularly have a working definition, but Congress directed us to implement these, and I'll turn to Commissioner, to General Counsel Berkovitz.
No, Steve is correct. The Commission does not have a definition of excessive speculation, nor that's correct.
Okay. So how does the Commission determine that price movements are caused by excessive speculation?
And again, the limits are designed to address traders with extraordinarily large positions. So they're targeted to the position size, not the impact that any particular trader has at a moment. These are based upon a formula, either based on the amount of available supply or the open interest in the market, designed to prevent a speculative trader from being extraordinarily large.
Okay. So the Commission did not attempt to conclude that the limits are appropriate if it cannot identify a situation in which excessive speculation caused an unwarranted price movement, correct?
Well, I think I'd like to clarify what the Commission in the rules determined the appropriate levels to prevent the undue burdens on interstate commerce that Congress has found results from excessive speculation. So the Commission's judgment regarding the appropriate levels for the limits that would prevent these undue burdens.
But we did, in doing that, we did not link up what excessive speculation was and the price movement they had in order to set these limits. We have just made a determination.
Pursuant to the congressional direction, yes.
Using ag formulas. We placed it using the
formulas.
25.
The formulas that we're recommending have been in place and been guidance in a variety of different physical commodity markets, as well as in financial contracts as well. And the citation of the agent provision is 151.5 A2 Romanet IV.
So today's position limit regime is largely designed to address, if anything, the undue accumulation, as you said, Dan, position owned by a single entity or person. How do today's rules address the overall speculation in markets brought about by the financialization of commodities, the herding phenomenon? And how will these rules address speculation by groups or classes of traders?
So in the proposal before you, we do not address, as we did not address in the proposed rule, trading by a class or group of traders. It uses the rule uses the traditional aggregation standard for two or more parties acting pursuant to express or implied agreement. And Andre, would you want to comment about a herding phenomena?
I think I would agree with Steve that, speaking of the rule before you, this is what the rule is supposed to do. And in my answers to Commissioner Summers and Commissioner Chilton, the phenomena that and it may be an interpretation of that we may need to make. Phenomena such as herding or such as taking positions that are going in the same direction, or taking position across multiple commodities that correspond to an index, for example. These are relatively new phenomena, and in this market, as you know, for every buyer there is a seller. So to the extent that the composition of participants on one side is balanced out by a composition of participants on the other side, and the risk profile of the marketplace is affected one way or the other, this is something that needs to be sort of further examined. And needs to be validated, and we need to find indicators of that. The rule before you looks at preventing large traders from amassing positions that could become destabilizing. To the extent there could be multiple participants who act one as large trader, we need to look at who's on the other side as well.
Thank you. The own non-financial. In our continuing attack on commercial businesses, we've compromised a previously workable aggregation rule and changed it to a more rigorous and unfair standard when compared to both public corporations and financial firms. What is the legal rationale for eliminating the proposed own non-financial aggregation exemption?
So the Commission did propose an exemption from aggregation for own non-financial entities. That is not in the current aggregation provisions in Part 150, and it's not in the staff's recommendation before the Commission today. That's correct.
So what is the legal rationale for eliminating it?
If I can just add a statement, I'm not so sure that I would characterize this as really a legal rationale for not adopting the non-financial owned entity. It's more of a policy rationale in that given that we are preserving the independent account control exemption, which largely addresses most of the disaggregation issues. And in addition to that, we are adopting new exempted provisions to address certain hardship situations, such as when we have traders that are prohibited by federal securities law from sharing information and therefore cannot come into compliance with position limits. We do allow for exempted relief or disaggregation. So given those two factors, we thought at this time it would not be appropriate to expand our disaggregation policy. Now, that is not to say that going forward with the Commission, the staff would not recommend to the Commission that we consider adopting some form of an exemption that mirrors or that it's similar to what was proposed.
I'm just totally confused as why we would treat them differently. Maybe you can explain.
No, actually, I think we've heard that from commenters that actually most of the commenters on the issue of this particular exemption, complained that we were being unfairly discriminatory to the to financial entities, because this was directed, the proposal was directed just to non-financial commercial entities.
Yeah, but and we fixed that. We responded to the concern, but we've treated these own non-financials, I think, in an equally unfair standpoint, and I'm just trying to figure out what the rationale for that was. We fixed that, the financial and the issue with the public corporations, but these commercial firms that are going to be forced to aggregate.
I should just clarify. I think when we say we fixed it, we're preserving mainly the status quo. The status quo is that commercial or non-commercial entities are not entitled to disaggregation to the extent that the position would, to the extent that their proprietary positions are involved. So we are preserving. So we're not necessarily, as I explained, we are preserving the status quo, and we're not expanding the disaggregation policy at this time. So I wouldn't characterize this as a matter of discriminatory treatment towards the commercials.
How will the Commission define identical trading strategies in this area in terms of aggregation for these non-discriminated entities?
Well, by way of example, I can envision a trader that has reached a position limit by going long in a particular commodity, and then entering a position, one or more positions, by buying shares of a fund that is long only. That trader, if we didn't aggregate that, would have a loophole to increase their position beyond the limit simply by buying more and more shares in a long-only fund. And they could replicate that by buying those shares in multiple long-only funds.
Is that the same for the owned non-financial?
That I will need some help on. I'm not connecting that up.
The aggregation rules are the same for the owned non-financial?
So the aggregation rules treat as a person. A company that owns equity interests in other companies, and we treat that one entity as a single person. That's the existing treatment under Part 150.
Does our ownership threshold at 10%, how does that compare to the SEC's rules, current rules?
Our ownership threshold is 10%, as you mentioned. It's been at that level for a very long period of time. Under case law at the SEC, generally control is presumed if ownership is greater than 25%.
Well, I have a lengthy dissent that I will include in the Federal Register to address this, and I have no further questions.
Thank you, Commissioner Malia. I know that Commissioner Dunn asked me whether we could include in our record Steve Sherrod's well-written response to his 10 questions for the public. Commissioner Dunn did a terrific service to the public and to the staff that he always asked. It used to be 9, now it's 10 questions on resources and the nature of our rules. And we commissioners do get those memos, but I'd like it in the public record is what you'd asked us to do. So, Steve, you now know that's in the public record as well.
Mr. Chairman?
Sure, Commissioner.
I'm sorry, I do have a couple other strays. When I reread my notes based upon all the good questioning from my colleagues, Commissioner Summers was talking about the deliverable supply issue, and she sort of left it on, so we're not going to do anything until 2014, and it sort of left it on the table. And my question is, can't we do better than that? I mean, is there some way that we can say we're not putting it off for, 3 years?
It's up to the Commission, literally.
But it's also, isn't it, it's up to an exchange. And if an exchange comes forward and petitions us and says, as they could have 4 months ago, and said, this one's too tight, 1,000 contracts or 2,500 contracts, and we can accept that.
And
is that right?
That I think the point I was trying to make is that, and Rick and I both made this point earlier, is that the deliverable supply, if they're using a long measure of deliverable supply, it doesn't tend to change that rapidly. The exchanges take the initiative to update their spot month limits, and to the extent an exchange finds a spot month limit to be too high rather than too low, they can, under the final rules, impose a tighter spot month limit.
If they knocked on our door in June of 2012 and said X spot month should be Y instead of Z, I mean, we might have to put it out to notice and comment, but aren't we allowed to put that out to notice and comment at that point in time?
Certainly, the Commission, as Commissioner Chilton noted earlier, we have that. We continue to have that discretion. The rule does not prevent the Commission from taking up any petition like that at any time.
Thank you.
Follow up. Can an exchange, because I thought I asked this earlier, can an exchange self-certify changes to spot month position limits right now?
There's nothing in the rule that would prevent that. The rule has a fixed schedule of spot month limits that would be implemented 60 days after the further definition of swap under Dodd-Frank.
Right. So the schedule for us changing them doesn't start until that 2014 date.
The schedule to initially implement them would be a few months from now, presumably, when the definition of swap goes final plus 60 days.
No,
the reset would be subsequently a couple years down the road. That's right.
That's the automatic reset. If an exchange wanted to come in, whether it's notice and comment or not, they can come in before that later date. Is that right, Dan and Steve?
Yes, that's correct.
Right, and that would be necessary if the exchange wanted to increase their level beyond what's in the schedule.
So a lot of this is dependent upon the exchanges. I mean, we might have to automatically do it every 2 years, and we're resource constrained, obviously. But if they want to come in earlier, I think they can.
And for the agricultural contracts, that's on an annual basis.
No. Right. Yeah. Sorry, Commissioner Chilton.
Okay, no, that was good. Commissioner Summers, did you have anything else on that one? Okay. No, I still have another one, Mr. Chairman. Apologize. I want to thank you, Mr. Chairman, and my colleagues for dealing with something that a number of us, including Commissioner Summers, had talked about. And that's in the amended version. Glad we fixed that excluded commodities issue. And thank you for the discussion, and thank you for including it. The last one I had was, Commissioner O'Malley got me thinking on, what's excessive speculation, and it reminded me, Potter Stewart on pornography. I know it when I see it. When I go out and give talks, I say, who thinks in the audience 80% of a market is too much? Everybody raises their hand. Everybody thinks 80% is too much. And then as you go down in percentages, they think less and less. And I say, well, ours is 10%. So here's what I know on excessive speculation. I know it when I see it. I'm not saying it's 10% or 11%, but 30, 40% of a market, 50% of a market, it's excessive speculation. And to be honest, what I've seen, some of it is pornographic when they own so much, and I think they've moved markets. So I don't have anything else, Mr. Chairman. Thank you.
I don't know where to go from there, but Mr. Staywick, do you want to call the roll?
Commissioner O'Malley?
No.
Commissioner O'Malley, no. Commissioner Chilton?
Aye, finally.
Commissioner Chilton, aye. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this matter, the yeas are 3, the nays are 2.
I thank you, Mr. Staywick, with the majority having supported the rule. This, too, will be sent to the Federal Register. It might take, I'm saying this to the public, a few extra days because there were these modest, but they're already typed amendments, but we just have to get these things in. I think I did unanimous consent to allow technical corrections to the documents voted on today. Did I do that? I just want to confirm I did that. Our next scheduled public meeting, I think, will be November 1st.
The subjects of the rulemaking presented in that meeting will be published on the Commission website 7 days before the meeting. If for any reason we don't publish something 7 days before, that's because we're not going to have a meeting on November 1st. But we do have things in front of the commissioners, and you'll find from time to time we'll do this in a rolling way. If there is no other commission business, then I take a motion to adjourn the meeting.
So move.
Second.
All in favor?
Aye.
I want to thank everyone again, thank my fellow commissioners, and I'm going to enjoy the rest of my birthday.